I'm just fine for you using the podium over here. It might be a little easier while people are still signing up. If you want to do that. We're going to have, this is House Bill 790. It regards the removal of timber from property of others, theft of timber. And we had this under a committee for this past session. So if you pull up House Bill 790, and Mr. Williams, I'm going to turn on your mic and let you get started.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I appreciate it. Bringing to you today House Bill 790. The LC we're working off of is a committee substitute, LC 295883S. 295883S.
Correct.
Mr. Chairman, I appreciate the thorough hearing that we got in Chairman Fleming's subcommittee. There was a little bit of perfection done on the bill that came out of that, thanks to Chairman Jay Powell, and we do appreciate that. This bill comes about as a result of a study committee which was chaired, Mr. Chairman, by you ably during the off session. Timber theft is something that this body has been looking at for several years, and we're pleased to be moving this into some definitive legislation. Basically, the bill does just a few things. First and foremost, in my mind, it empowers the Georgia Forestry Commission, the state forestry agency, to investigate timber theft. Their investigations will be supplemental to and in addition to local law enforcement, which obviously has and would retain that ability to investigate timber theft. It also has provisions for landowners who are selling timber lawfully. It has some optional provisions where if they want to take certain steps on more clearly delineating their property lines between themselves and their neighbors, should the timber harvester cross the property line, if the landowners have taken those optional steps, Mr. Chairman, it gives them protection. It more clearly defines how record keeping of wood that is transported, what we call scale tickets, how those have to be delivered to the seller or his or her agent in a timely fashion, and it contains treble damages for timber that is illegally removed and timber that would be damaged in such illegal removal. With that, Mr. Chairman, I would ask obviously for favorable consideration. We'll stand for any questions.
Thank you. Let me ask you to, if you could, briefly point out, or maybe I can get Mr. Fleming to do it, where we had changes from the bill that was originally introduced.
Yes. The changes were line 126. Chairman Jay Powell suggested we had some language that basically said unequivocal, if you will. Chairman Powell suggested that we insert, I guess, more common sense wording, Mr. Chairman, that a reasonable person would be able to see those property boundaries, and also on lines 130 and 131, reasonable person language there as well.
Thank you. That's good. Thank you. Any questions by members of the committee of Representative Williams as a presenter? See none, and I appreciate your explaining the bill to us. Is there anyone here who wishes to speak on House Bill 790? I believe I do have one back here. Ms. Clifton.
Yes, sir, Mr. Chairman.
Hey.
Wendy Clifton with the Georgia Trial Lawyers Association. Just really want to say thank you to you for having the study committee and working with Representative Williams and the Georgia Forestry Association with the language that you just called out a few moments ago in the latter part of the bill around the issue of liability and treble damages. We really appreciate the effort and think this is a great bill, and are going to work with the chairman to get it passed. Thank you.
And thank you. Thank you very much, Wendy. Anyone else wish to address the committee before we close off public comment? If not, we will close off public comment on House Bill 790, and the bill is now in the breast of the committee. Is there any discussion among members of the committee regarding this bill? If not, the chair will entertain a motion. Have a motion to pass, and it's been seconded by, who was it? Mr. Kelly, thank you. Any further discussion or any amendments to the bill? There being none, the chair will call for a vote on the motion. All in favor of the motion do pass. House Bill 790 as a committee substitute signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you, Representative Williams. Let you get on to your other business. Yes, sir. Next we have House Bill 670 by Representative Fleming. And I'll get your mic on, Mr. Fleming, and let you address the committee on your legislation.
Thank you, Mr. Chairman and members of the committee. And if I would ask Mike Holloman and the clerks you brought with you, if y'all come on up in case we have any questions. Mr. Chairman, this is Mike Holloman with the clerks of Georgia, and he brought several clerks with him. The pretty one he brought is my clerk from Columbia County. I don't know about the rest of them over here.
I'm glad you weren't addressing Mr. Holloman that way. He's letting his hair grow out. I know that, though.
It just got curly. I don't know.
Mr. Chairman, the bill before you today does one thing, and that allows for a statewide system through the Clerk's Authority for our citizens to be able to view trade name registries at any courthouse in Georgia. As the committee is probably aware, over the last couple of decades, we in Georgia have made significant advances to allow our citizens to be able to go online and use the internet to look at records at the courthouse that they used to have to go in person or hire someone to do, UCCs, deeds, and so forth. This is one of the last things that is not online, and that is trade name registries. As you know, if I'm going to do business as somebody else other than Barry Fleming, I have to go down and register that trade name so the public and everybody else will know who Joe's Bait and Tackle Shop is, for example. This will follow the same format that we've done in the past with other electronic records. There will be a $5 fee when you go and register your trade name added to it. That money goes solely to allow the Clerk's Authority of Georgia, which is an agency that coordinates activities for several of these electronic filings, as well as other matters with our clerks across the state, will allow them to fund the system that actually puts these online. Mr. Chairman, that is basically what the bill does. There's some cleanup language that Ledge Council found in there of a code section that hadn't been touched in a long time that made some very minor changes, but that is the nuts and bolts of the bill. Mr. Chairman, of course, if there are any questions in more detail, I'd be happy to elaborate on that or answer if I could.
Yes, sir. Any questions of Representative Fleming by members of the committee? I see none. Ms. Halbman, would you and your lovely clerk like to address the committee?
No, we just want to amplify on Representative Fleming's statement. It is indeed just one more collection of data that we think will serve the public to allow a person to easily see who has registered under certain trade names.
All right. Just a couple of thoughts to it, and that is, of course, trade names apply to a specific geographical area, usually a county.
That's correct.
And so you could have, as I use example, 5 restaurants in Georgia using the same trade name as like a restaurant
Yes,
would do, and that doesn't change. It only be applying if they've had 2 of them in the same county where one had a registered trade name. They could stop the others from using that, correct?
That's correct. It does not have statewide applicability.
And this doesn't change that.
It does not change that.
Okay, the other thing, I look on line 78, is there a time limitation for a registered trade name?
No, a time limitation, there is not.
And I guess I'm questioning, what does the re-registering a trade name
The
mean?
re-registering would allow an individual doing business as a certain name to have their registration put on the state registry, on the online
In other
registry.
words, Mr. Chairman, everybody, if I may, before this date, if we pass this bill, is not going to be on the statewide register. They're not going to be online. So if you want to come in and make sure that your business is online where people can see it, then this allows you to do that.
Okay, yeah.
Provides for
Would that be
re-registration.
understood as to what that meaning is?
That's exactly, it's understood by the Superior Court clerks. And one other thing that we did in the bill, as you may know, the trade name registration is subject to the JOF $125 fee. We have
What's
not
JOF, excuse me?
Judicial Operations Fund.
Okay.
The JOF fee is applied to the initial registration of the trade name. However, we did not want that $125 to apply to the re-registration or the cancellation. We didn't want to touch the current revenue that's being collected because it is a fairly substantial amount of money.
Yeah. So if you had someone, is that spelled out in the bill?
Yes, sir.
Yes.
Okay. Any other questions from anyone on the committee? Anyone else? Yes, sir. Mr. Welch?
Mr. Chairman, would it be appropriate then, if this is unclear on line 78, would it be appropriate then to consider some language that might clarify it, such as registering an existing trade name in the trade name registry?
I'll be open for amendments when we get to that point. Yes, sir. Any other comments or questions of the presenter or the two individuals here for the Clerks Association? If not, anyone else wish to speak to the committee on this bill? There being none, the chair will close off further public comment. The bill is now in the breast of the committee. We're dealing with HB 670 under LC 40-0509S as a committee substitute. Any discussion among the members of the committee? There being none, the chair will entertain motions. Do we have a motion? Motions do pass and seconded by Mr. Welch. Is there any amendments or other discussion to the motion? Mr. Welch.
As a friendly amendment to the sponsor, if he would be willing to accept it, propose an amendment to line 78, striking the letter A, the word A, and inserting an existing, and then after the word name, inserting in the trade name registry.
All right, so you make that in the form, in the state trade name registry, or what do we call it?
It's identified as the trade name registry. If we
The
wish.
state or nothing? Okay, trade name registry. And there's a second by the author of that proposed amendment. Any discussion on the Welch amendment? If none, the chair will call for the question on the amendment. All in favor of the amendment as stated signify by saying aye.
Aye.
Opposed, like sign. Motion carries to amend. Do we have any other amendments? There being no further amendments, chair will call for the main question, which is a due pass to HB 670 as amended and committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Yes, sir. I know some judiciary here today. I've got a dear friend, old friend of mine, who has been sitting as a Superior Court judge over the Coweta Circuit, and that's our former Senator Bill Hamrick, and now Judge Hamrick of the Superior Court. Judge, you stand up and we'll have everybody recognize you, and thank you for coming in today. As a senator, I can say it was a great honor and opportunity to work with you on a number of things of legislation, and we always had a very good relationship. I'm grateful for that. Is there anyone else here with the judiciary or the district attorneys group? Not. We'll go forward with other bills. Mr. Atwood. Oh, Mr. Barr here? Is Barr here yet? Barr. Let me get Atwood. I think it'd be quick on his, then we get yours. Thank you. Have you got two? Okay. Then we'll hold up and get both. Go ahead, Representative Barr. Would you come forward on your bill? This will be House Bill 701, the next down in your package. Yes, sir. And Ms. Quick, please join us. Glad to see you here, both together.
Thank you, sir. I am glad to be here with my colleague that can answer some of the technical questions about this bill. 701 is, it came out of the Child Support Commission, which was reactivated this summer. There is definitely a distinguished list of individuals on that. I'm not sure why I was chosen. However, serve at the pleasure. We have Court of Appeals Judge Branch, we have Superior Court Judge Abbott, Baldwin, Campbell on this committee. Therefore, I feel very confident on what we can present to you today. There's several changes, corrective language, clarifying definitions, and there are a few more substantive changes that I would ask that Representative Quick address to the committee.
Please do.
Thank you, Mr. Chairman. And of course, although Representative Barr is not a lawyer and knows nothing about child support,
Doesn't pay it either, does he?
He doesn't. He's happily married and hopes to never pay it.
That always helps.
But he has really, gotten himself up to speed, including working with the State Bar Family Law section in having us review these changes before they were presented and the bill was dropped and filed. But this is a cleanup bill, but the summary is particularly helpful because there are some substantive changes that are requested by the Child Support Commission. And of course, as you know, but some may not know, each state is required by federal law to establish child support guidelines, and the guidelines are a condition of receiving federal funds for TANF, temporary assistance to needy families. So this is part of the review in that process. And the summary, I'll just hit the substantive changes. The first one is in Section 4 of the bill, and it adds veterans' disability benefits to the definition of gross income and the definition of income that must be included in gross income when calculating child support. And when we had the subcommittee meeting, I went through the child support guidelines, how they work and how they operate. I won't repeat that unless somebody needs me to in this process. The next substantive change is in Section 6 of the proposed legislation, and it removes the limitation on the judge's ability to consider a low-income deviation without a specific request from a litigant. That provision of the law has been in place and actually came from the Low-Income Deviation Study Committee from several years ago, whereby the litigant actually had to ask the judge to consider. This change will allow the judge to take into account the serious financial considerations of a low-income litigant and employ and apply that low-income deviation without a magic request from what often and many times frequently is a pro se litigant in that context. The next substantive change is Section 8, which allows and authorizes the court to rely on the worksheets prepared by the Division of Child Support Services if neither parent prepared a worksheet. And in that context, I don't know if you're working in your folder from a committee substitute from the subcommittee work. The most recent version online did not have the change that the subcommittee made in it.
All right, let's work. We're working from LC 295882S.
And so you have a version which on line 290, if you could just indulge me, has removed the word solely, and it now reads, in child support services cases in which neither parent prepared a worksheet, the court may rely on the worksheet prepared by child support services and no longer has the word solely.
Okay.
Because that is the change that is the only change that the subcommittee made in their work. The next substantive change is it changes the review period for the basic child support obligation table from every 2 years, which is what the initial guidelines had, to 4 years, which is the requirement under federal law. So those are the substantive changes in the bill. And on behalf of the Child Support Commission, I'm happy to answer any questions, try to present their version of this to you, and would ask for favorable consideration.
Thank you, ma'am. Appreciate that, Ms. Quick. Mr. Welch.
Thank you, Mr. Chairman. Question on, this deals with the definition being struck under lines 16 and 17, the adjusted child support obligation being struck, and then we're striking that, and I just wanted to know why we're striking that, and then on lines 253, we're striking the word adjusted and going to basic, and I just wanted to get clarification on why we're doing that.
The first question you have, Representative Welch, is on line line 16 through 17. This is a proposed provision intended to remove duplicated terms.
Okay.
And the language that is removed here then appears elsewhere in 19615. So it shows back up later. This was just trying to clean up and make it less cumbersome.
And I guess in that same term, is it basic child support obligation now? Is that the actual the term that's used in Title 19.6?
The basic child support obligation is the amount that was set by the General Assembly when the guidelines were enacted and went into effect January 1st, 2007. That's the presumed amount, or I should say the set amount for parents who are divorcing in a certain income bracket. So the two gross incomes are added together. The theory behind the guidelines being that this is the amount those parents would have spent on a child in that income range had they remained married and trying to keep a child of divorce in the same economic circumstance that they would have been in had their parents not divorced. So the term basic child support obligation makes reference to that.
Okay, thank you.
Thank you. Any other questions? Just quick, let me ask one, or you or Mr. Barr. We have the term child support services used in this bill in several locations. Is that a defined term in the law, or do we know what we're talking about when we say child support services? I think that may be something that goes from jurisdiction to jurisdiction, as having someone either working in a judge's office or whatever. It could be child support services. What do we mean by that?
I will let somebody else weigh in if they know more than me, Mr. Chairman, but my understanding is that is the most recent version of the technology, or the terminology, I should say, that is utilized for the state agency that collects child support on behalf of
So part of DFACS, you
parents.
mean?
It's no longer DFACS. It is the division of this
Division
language
of Child Support Services.
Yes.
Okay. I'm asking if we need to do something as far as a definition within the bill of this term.
I don't believe so, Mr. Chairman, but if you want to give me a minute, I can scroll through here and see. I think it's defined elsewhere in Title 19 in terms of the collection.
Because I notice at the beginning in Section 1 we have terms being defined, and I'm not sure if that's within that group, because it goes just certain ones where we made modifications, but not all of them, of course.
It is certainly, I don't believe, separately defined in the child support statute, but I believe elsewhere in Title 19. But we do have the staff attorney for the commission who's here, if you'd like to hear from her on that.
Would you mind stepping forward and let us ask you on this, not concern, but just question of whether we've got, and we'll let you come around to the podium if you like, and we have both of you and Ms. Quick and Mr. Barr able to communicate with us. So you give us your name and where you are employed.
Good afternoon. My name is Pat Bonadono, and I am the staff attorney for the Georgia Commission on Child Support. I'm employed by the Administrative Office of Courts through a contract with the Division of Child Support Services.
All right.
And the Office of Child Support Service Division, I'm sorry, it changed, Child Support Services is defined elsewhere in 19.6 and was actually referred to using different names.
Okay.
And so there were some corrections made so
Okay.
that it was consistently used.
So what we've got is this is a section of Chapter 6 of Title 19, and there is a definition in Chapter 6 somewhere else as to child support services. Is that what we understand?
Yes, sir.
Okay. Could you just, if you have it there in hand, could you tell me where that may be located?
I am looking at my notes to find that.
And Mr. Chairman, while she's looking, many of these changes in the cleanup went from what we used to call the 4D agency to Child Support Services to hopefully capture whatever name change, nomenclature change there may be in the future.
Good.
Okay, this does not specify that there is a definition.
Do you feel there's a need that we know when somebody reads this out in the hinterlands who we're talking about as far as child support services, that there's an agency that has a longer name than that, but we use that as the abbreviated name?
Does it, it should say Division of Child Support Services or even
Well,
Department.
we can use the abbreviated term, just
Right.
somewhere we define who that is as a specific defined or stated agency. And the agency's name is the Division of Child Support Services under what?
Under the Department of Human Services.
Under Department of Human Services.
And
We
Mr.
don't have anybody here from Legislative Council, I'm afraid, do we?
And Mr. Chairman, I don't have all of Title 19, but at least part of 19615 makes reference to the applicability of the guidelines if the action is filed in a Child Support Recovery Act or Uniform Reciprocal Enforcement of Support Act or UIFSA Act,
Yeah.
which I believe is where all these definitions are, but I'm sorry, I don't have it.
Yeah. I might just urge that we have that put into it,
Yes, sir.
so we know when everybody starts reading that, who we're referring to as having this decision-making.
Added as a
part of it.
definition?
Yes, ma'am.
Yes, sir.
Pardon me? I'm going to ask that in a second, yeah. Anyone else wish to address the committee on House Bill 701? If not, the chair is going to, on its own prerogative, table this bill for the moment till we get that cleared up. Yes, sir, you got? Underwear definition suggested child support services means agency within the Department of Human Services which provides and administers child support services. Okay, and that's under 19615. Okay.
All right.
So we did find a definition, and that is a part of this section we have.
Yes, sir.
Chair is satisfied. Chair puts the matter back before the committee. We're satisfied we do have a definition then. Thank you. Thank you very much. Anyone else wish to address the committee? If not, the bill is now in the breast of the committee. Is there any discussion among members of the committee? If not, the chair will entertain motions. Motion do pass and seconded. Seconded by Mr. Mabry. All right, thank you. Any discussion or amendments? No further amendments, no further discussion. The chair will call the main question. The question is do pass House Bill 701 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, same sign. Matter carries. Thank you. Appreciate your help. Yeah. I'm going to go ahead and just do it myself. Okay. I'm on the bill. I want to get moving. Get my sheet back up. Moved it somewhere. We have the next bill is the yours, I believe, Mr. Atwood, House Bill 776. You would come forward. Let me get your mic on for you.
If I could, with the chair's permission, ask Mr.
Certainly.
Holloman to join me.
Sure.
I actually have two measures, and the first one I would wish to discuss with you, obviously, is House Bill 776, but what I'm going to, the statements I'll make refer equally to House Bill 890. Back in 2011, in fact, Judge Hamrick helped me with this bill. It was the Jury Composition Reform Act of 2011, which was one of the first bills that I brought to the House and to the committee and passed successfully. It was a 7-year work. Had strong support both sides of the aisle, as well as with the judges and the prosecutors and defense attorneys and everybody else. In fact, frankly, what it did was it took care of a problem that existed in Georgia. Our way of selecting jurors was getting dangerously close, being found to be unconstitutional. I believe the Sixth Circuit had already ruled at that time, And we used a system called force balancing. And in that system, we basically considered only black, white, male, female. We got many of our jurors off the voting rolls, and we were ignoring many other groups, Hispanics, Asians, and others. And so what we put together is a way of gathering other data. Not only do we use the Broder's list, we use the driver's license list and other lists to bring in folks that would allow a true impartial jury of one's peers. We have learned since that time some lessons, and we're trying to correct. This is literally cleanup language for that original act that passed back in 2011, and the Council of Superior Court Clerks has asked for this. I also have a document from the Judicial Council of Georgia. I have not provided it to the committee. I did provide, I think, to the subcommittee. But the Policy Committee of the Administrative Office of the Courts, Judicial Council of Georgia, recommends that the Judicial Council support this legislation to remove the reference to jury commissioners in the Georgia Code, and number 2, to amend authorization so that the Council of Superior Court Clerks can receive data to refine the master jury list. And Mr. Chairman, that is essentially what this bill does. With the subcommittee, I went section by section, but mostly what it does is it strikes antiquated language, such as the Board of Jury Commissioners. They essentially do not have a role anymore. It also, you'll see a lot of underlined language in Section 2, Section 3, Section 6. That is not new language. That essentially moves language from 151223B to 151212. It's stylistic language changes and removal from one section of code to another one. 151223 to 151212, and you'll see that throughout this bill. One thing it also does is it requires felon lists to be provided by the Department of Corrections, Pardon and Paroles, GCIC, and each agency is unique, and we ask them to provide that information to us so that we can better put together our jury list. Mr. Holloman, did you have anything to add?
Only that the existing statute calls for the council to receive a list of felons from the Secretary of State. That list of felons, however, is incomplete for purposes of assembling jury pools. For voting rights, a felon is considered to have regained voting rights after they've completed their sentence, either their active incarceration or finished probation. It's not as automatic to have your rights to serve on a jury restored, and we are getting a much more complete list of felons by going to each of these 3 agencies. We met with them last summer. I have to say that GCIC, the Department of Corrections, and Pardons and Paroles have all been outstanding in offering to support this effort.
All right, thank you. Thank you for that oversight and review of the bill. And it's not unusual when we pass as large a bill as we did with the jury composition bill that we come back a year or 2 later doing some further tweaking of it as we have some experience in application of it. So that's frankly what we're doing here, is it not?
I think, Mr. Chairman, I think I had to have 2 grown men and a small boy to lift that thing. It was about that.
Pretty good sized bill.
It was.
Any questions by members of the committee of the presenters? Yes, sir. And yes, is that you, Judge? Yes. Please, you all right? Pull your mic around. I'm looking at 27.
Line 74, please, where it starts on page 3. You with me, Alex? Mm-hmm. It says in there that the chief judge of the Superior Court shall have the power to appoint a jury clerk and such other personnel as may be deemed necessary and advisable in the appointment of such positions, and the compensation shall be determined by such judge. Where's the judge going to get the money to pay that? Unless he goes to the counties and gets it pre-approved by county commissioners.
I'd be glad to answer that question.
Yes, sir. Go ahead.
This is one of those sections that Representative Atwood referred to that is current law. It is underlined, but that's only because Legislative Council restructured the code section and moved it to this number. In counties over a certain population, Gwinnett, Cobb, DeKalb, Fulton, I think Richmond County, Muskogee County, Chatham County, in those counties, the judge is authorized by statute to appoint their own jury clerk. And this simply retains that language.
What about the other counties?
All other counties that aren't covered by this particular language, the jury clerk is the Superior Court clerk.
Do they get any additional enumeration for doing that?
They do.
And how much is that? Is it by a percentage basis, a population?
No, sir. It's for purposes of excusing and deferring jurors. I believe the number is $323 per month.
Per month? Okay.
Is that by statute?
Yes, sir.
All right. Anything further, Judge?
No, sir.
Anyone else have questions of the presenter? If not, we appreciate that. Does anyone wish to address the committee on the bill, which is House Bill 776? Yes, sir. You'd like to come up to the podium and give us your name?
Yes, this is Lamar Wise. I just had a couple of questions about it. You were saying that there's some delineation between the rights to be on to vote versus a jury, and I wondered what the history of that was, if you could answer shortly.
There is a statutory provision that I can't quote in the voting section of the law that says that when a person has satisfactory, and I'm paraphrasing, that essentially says that when a person's satisfied their sentence, they are eligible to vote. There is no such language that applies to full citizenship. To get full citizenship restored, you must go to a hearing at the Pardons and Paroles Board.
Yeah.
Okay, and then that would allow people to be on
That
the
would
jury.
allow people to be added back to the juror
That
list.
would, infringe on people's freedom after that point. And you also said that the Board of Jury Commissioners serves no purpose now? Is that?
That's correct.
So what happens to this board?
Well, we're eliminating it with this bill. In the past, when they had force balancing, the jury commissioners with the jury clerk did a
let me answer to it, because what we're doing is say the bill that was passed previously recognized that all the jury pools would be formulated at the state level by the big computer we got for that purpose, and then the list would come down to the individual clerks as a call for information to begin forming a jury list, whether it be for criminal or civil work. So there's no longer a formulation of a jury list per se at the county levels. It's all done through the state.
Thank you for answering my question.
Yes.
I know how important the juries are.
Truly
and
is.
there are very few jury trials statistically.
Every
it's going
citizen,
down.
we hope, stands and comes forward when they're called upon to serve on juries, because without it, our judicial system and our whole system of this country would fail.
Mr. Chairman, if I could add.
Yes, sir.
If I could add one thing.
Pull your mic
This has
around.
This has actually been challenged, I've been told, about 6 times. And since we passed it, been held constitutional every time. And I really am a strong supporter of the original bill that we passed. I think it gives more of an opportunity for people to serve on a jury, and I strongly encourage that. I think we
Thank
all
you.
do.
Good point.
It also
we
helps
do
save
we
money.
do believe we've improved substantially the old system
Yeah,
that we have in putting together the jury pools, and it's a great program.
It also helped to save money. The clerks, as I understand it, were sending out summonses. A lot of people had moved, and one of the programs we use is to it's a way to identify people that have moved.
Correct.
So we now don't waste our postage and that sort of thing to get it out to
Good
vote.
point.
So,
Is there anyone else who would like to speak to the committee on House Bill 776? If not, we will close all further public input. The bill is now in the breast of the committee. Is there any discussion among committee members? There being none, the chair will entertain motions. Is there a motion on 776?
So moved.
Thank you. Wanted to fail for lack of a motion here.
pregnant pause.
All right, we've got a motion by Mr. Jacobs, seconded by Mr. Welch, I believe. Any further discussion on the motion? Any amendments to be offered? There being none, the chair will call for the question, which is a due pass House Bill 776. Has this been amended at all in subcommittee or anything? It's as presented then. All right, thank you. All in favor signify by saying aye. Aye. Opposed, same sign. Motion carries. Thank you. Senator Cowles, I'm sorry I didn't see you back there, and I would have tried to get you up a little earlier perhaps. You're here on an important matter, which is the resolution from the Senate on 371, Senate Resolution 371. We're going to call that up. There's a number of people who have signed to speak on this particular measure. I'm going to try and recognize everybody. I would like to suggest if your main desire is to voice your support for it, we'll allow you just to say you're in favor of it if possible. As quick as I'm looking down the list, I've got probably I'm gonna guesstimate about 20 people, and let me just before you start, Senator, there's a Jack Staver. Is that for this bill? Because you didn't put which bill. All right, 371. Thank you, Senator Cowles. Glad to have you with us.
Thank you, Mr. Chairman. I appreciate you allowing me to be heard in this topic, especially before crossover day. I appreciate your consideration. I was here 2 years ago in front of your committee with the almost identical bill that Representative Welch co-sponsored here in the House. We had corresponding resolutions and got out of your committee but never got on the floor of the House. And then again last year, we were here with this bill, and it did pass your committee and got through your Rules Committee but didn't get called for a vote on the last day. So I'm not going to give the 30-minute presentation since I feel like this committee is aware of the provisions of this resolution, and there has been a good bit more public discussion of the Article 5 process in the last 2-year period that we've been dealing with this topic. So I think most people are much more educated on this constitutional provision than we once were. So I won't start this off as a political science 101 course. I'll jump right ahead and just tell you what we're trying to accomplish. This is an application to be submitted to the United States Congress calling for an Article 5 convention, that is sometimes referred to as a convention of the states, or more commonly an amendment convention, for the limited purpose of considering a balanced budget amendment to the United States Constitution. Article 5 provides two mechanisms for amending the Constitution. One is if an amendment is proposed by the Congress, which requires a 2/3 vote of each chamber, and then submission to the states for ratification by 3/4 of the states. That has not worked in this case. The United States Congress had this vote 2 or 3 years ago, and it did not pass the balanced budget amendment. So that door has been closed to us. There is not a 2/3 majority in Congress that is willing to impose fiscal constraints on themselves. I think we're fortunate here in Georgia that we do have a constitution that requires us to balance our budget, and we have lived within our means even through this great recession of the last several years that's been very painful. But it's a responsible way to govern. 49 of the states have such constitutional or statutory provisions, and all live within their means. The alternative provision, where Congress will not take action and propose this type of amendment, is that 2/3 of the states may petition Congress and apply for such a convention to be held. That requires 34 states to do so. Upon receipt of applications from 34 states, Congress must call a convention of the states for the purpose of amending the Constitution. This asks for it to be on the limited subject matter of a balanced budget amendment, and it sets forth in this application that we want that to be at lines 18 and 19, in the absence of a national emergency, the total of all federal appropriations made by Congress for any fiscal year may not exceed the total of all estimated federal revenues for that year. It is very intentionally subject matter specific, but does not give the exact wording of the amendment. That would be agreed upon by the convention once it convenes and as it's appointed. You're going to see several groups here today. I would anticipate quite a few in support of this, as it is certainly gaining traction nationwide. 20 states have now passed identical or similar single subject matter resolutions such as this for a balanced budget amendment, so we're well over half the way there. There are 5 or 6 other states actively considering this exact amendment at this time, so it looks like we're gaining momentum to get into the 34 states. A couple of years ago, I had opposition, specifically from the, I guess it's called the Atlanta Tea Party Patriots, Julianne Thompson and Debbie Dooley's group. I had some Tea Party organizations in the state in favor, some against. You will see the John Birch Society is opposed. I think the Eagle Forum is opposed. Those that are opposed to this have generally been people that had fears of a runaway convention, that the convention might consider other subject matters other than the one we call for here. Those people have changed their minds, or some of those people have changed their minds over the last couple of years. Debbie Dooley and Julianne Thompson's group now support this. The Georgia Tea Party Patriots support this. I know the Walton County Tea Party Patriots support it because that's in my district. And there's Mark Levine has written a book called The Liberty Amendments where he is in support of this process. I think as the opponents have become more educated and realized that the convention itself does not have the power to pass an amendment to the United States Constitution, that the opposition sort of melts. Once the realization sets in that 3/4 of the states would have to ratify any amendment proposed by the convention, and that alleviates a lot of fears of any runaway convention. We went a step further last year and had what's referred to as a Delegate Limitation Act. It's Senate Bill 206, which has passed your Interstate Cooperation Committee. I think that's what you call it here, Matt Dollar's committee, and is in Rules Committee now. That sets forth the mechanism for selecting delegates from the state of Georgia, and also requires them to have an oath of office that they will confine their deliberations to whatever our application for convention asks for. And in this case, it would be only a balanced budget amendment. And also to be limited by whatever legislative instructions the legislature may give to our delegates as they go to the convention. That allows us to recall any delegate that were to veer away or consider any subject matters other than a balanced budget amendment, and also makes it a crime, a violation of their oath of office, which is a felony offense if they were to do that. Once people realize that we do have control over our delegates, that they will not be considering amendments for other subject matters, then I think that further dissolves any of these fears of some type of runaway convention. You know, some people have said that desperate times call for desperate measures, and I think that most all of us would agree that our federal fiscal condition is in the worst shape it's ever been in the history of this country, and it is certainly in desperate shape. We're over $17 trillion now in federal debt that's sort of on the books, and there's another $79 trillion of unfunded liabilities that are out there for us, and it's certainly going to be quite a burden to impose on future generations if we do not get this under control. And so I would strongly urge consideration from this committee to pass this application out of committee so that it might be considered by the House. It passed the Senate last year, along with the Delegate Limitation Act, with bipartisan support. And I would mention that this resolution, it is replacing one that Georgia first passed in 1976 when we were almost 100% Democratic. This is not a partisan type issue. That was rescinded back in 2004 when we had a number of these applications on varying topics that we kind of had a cleanup bill. Any bills, we took off the books laws that were sort of void or lingering or whatever, no longer current. And I think back in 2004, the legislature rescinded all pending resolutions instead of just letting them stay out there indefinitely. I don't think that was a statement as to the usefulness of the application or the validity of it, but I think it was more of let's clean up some of the unused laws that are on the books at the time. So I think this is a issue that's supported by both Democrats and Republicans, anybody concerned about the fiscal security of this country. I'd be happy to answer any questions you may have, Mr.
Thank
Chairman.
you. Thank you, Senator. Any questions of the presenter? We do. Yes, sir. Judge?
Yes, Senator, you spoke concerning having our delegates selected as well as under oath. But what happens if, let's say, we have more than 34 states? How can we control their delegates?
Couldn't control those delegates, what they
that's
might vote or what they might propose.
Well, then couldn't
you have to have 3/4 ratify anything that could come out of that convention.
Right. Well, couldn't you then have amendments and them, as I use the term because it's been used, a runaway convention then? We could control ours, but we couldn't control the others.
That is true.
Thank you.
Mr. Welch.
Senator Cowser, I wanted to thank you again for bringing this resolution and then also working diligently on the delegate control or delegate authorization bill 206, Senate Bill 206. A question that doesn't pertain to the resolution, which I'm supportive of, but on your delegate limitation bill, I know that I think it's already moved into rules, but out of curiosity, would you be willing to entertain some amendments to how the delegates are chosen?
Certainly.
Okay.
Yeah, I will tell the committee how that was decided. It was to give the governor 2 appointments, the lieutenant governor 2 appointments, and the speaker 2 appointments. Then those 6 delegates would select among themselves a 7th delegate, so it would be an unequal number.
I believe you have it as the president of the Senate.
Same difference.
Okay.
Our president of the Senate is the lieutenant governor. And Judge, to your question earlier, this Delegate Limitation Act, we're not the Lone Ranger with that. Most of these states already have that in place as well. So we go into any convention with a certain assurance that the majority of these states also have their delegates limited to that single subject matter. So it's not just the Wild West like I made that sound that we can't control them. But technically, we can't control how other states do. But from a practical standpoint, they have the same limitations in place.
All right. Does the Constitution call for the number of delegates?
Does not.
And so how is that going to be determined?
Different states can do it different ways. The universal principle in what's imposed in our Delegate Limitation Act in this is that each state will have 1 vote. Now, how they go about selecting, appointing the numbers really should not be relevant to us as long as each state gets 1 vote on any proposal.
So our 7, assume we have 7 delegates, there would be a majority to decide what would be the vote.
That's correct.
Okay. Anything further from the presenter? I appreciate your efforts on this. I'm going to
Thank you so much.
Have comment. I'm going to ask to do this. We've got so many people signed up and want to give everybody the opportunity that wish to speak. And what I suppose we would do first is let those who are in favor of the proposed resolution, Senate Resolution 371, come over here to the podium, if you would, and we will allow you as opportunity to speak. I ask you to speak as the brevity, since we do have a number. Give us your name and your comments to the proposal.
Thank you, Mr. Chairman.
Let me get to open.
Thank you, Jack Smith from LJ, Gilmer County.
Yes, sir.
I speak in favor of 371 because it is one of the tools that the founders gave us to maintain control over a central government that is supposed to have enumerated powers. This is one of the vehicles that we can use to ensure that they implement fiscal responsibility. Just as we have here in Georgia, I speak in favor of the bill along with many others across the state. We'd appreciate a positive vote on your behalf.
Thank you, Mr. Smith. And the next person, please, name and...
My name is Lauren Enns. I'm a member of the Balanced Budget Amendment Task Force. We are the national organization that has organized to push this through to 34 states. Just real quickly, I'd like to offer you a few quotes of some of the greatest presidents we've had and the support that they've offered for this mechanism. When speaking on the state's rights to propose constitutional amendments, Abraham Lincoln said, "This country with its institutions belongs to the people who inhabit it. Whenever they shall grow weary of the existing government, they have the right to amend the Constitution. I will venture to add that to me, the convention mode seems preferable in that it allows amendments to originate with the people. We, the American people, are weary of the massive debt Washington has foisted upon us and future generations. And like Abraham Lincoln, we trust you far more than we trust Congress. I'll skip down since we have a lot of people who want to have their say. In 1994, Ronald Reagan wrote a letter encouraging the states to continue the fight to propose a balanced budget amendment via a state convention. Ronald Reagan, when he came into office, got behind the movement both to propose a balanced budget amendment through Congress and through the states, and fully supported both. This is what he said. In that letter, Reagan wrote, "We can't depend on Congress to discipline itself. We must rely on the states to force Congress to act on our balanced budget amendment. Fortunately, our nation's founders gave us the means to amend the Constitution through action of state legislatures. That is the only strategy that will work." Reagan watched the Senate propose a balanced budget amendment in 1982 and then watch it die in the House. For 40 years, a balanced budget amendment has been at the forefront of national discussion. 75% of the American people support it. In 40 years, Congress has never, ever proposed it, and so it is left to the states. Ronald Reagan trusted the states, Abraham Lincoln trusted the states, and we, the American people, trust you. And so I would ask that you support SR 371. Thank you.
Lauren Adams, was it?
Ends.
Ends, excuse me.
Yes.
Next, please.
My name is Gail Engelhardt, and I am a district captain for the Convention of States, Article 5. I, too, would like to read something to you from our founders, and it's from George Mason. He happened to add to the portion of Article 5 that we're talking about here today, I'm going to make a decision on. It says, the second clause of Article 5, empowering the states, is necessary because left to Congress, no amendments of the proper kind would ever be obtained by the people if the government should become oppressive. And I think we can all agree that we have an out-of-control federal government. Just take a look at our deficit. Also, there is something that Alexander Hamilton said. He said it must be utterly repugnant to this Constitution to subvert the state governments or oppress the people. And what he was saying there is that the states have the right to rein in the federal government because they formed the federal government in the first place. And we trust our state representatives. You're closer to us than any of the people in Washington, D.C., to know what the citizens want from each and every one of you. So I thank you for your time, and of course I am for an Article 5.
Thank you, Ms. Engelhardt. Glad to have you here. Next, sir.
Thank you, Mr. Chairman, members. My name is Louis Marin. I'm a retired Navy Chief Petty Officer, 22-year Gulf vet. I came home and very dismayed to see our country that has gone off the reservation regarding deficit spending. I'm very concerned to know that our Congress spends $6.8 million a minute. I've been sitting here for approximately an hour and a half now. When you try totaling that up, that's over $500 million. I'm very concerned for the future of our country. This is in my mind, a nonpartisan issue. 75% of the Americans want a balanced budget. I live on a budget, and I can bet probably $100 you all live on a budget. I bet you the people here live within a budget. Why can't our federal government get it? It bothers me the fact that when we go bankrupt, and we will go bankrupt in 5 to 7 years with this kind of spending, $6.8 million a minute. Who's going to suffer? The elderly and the poor are going to suffer. People don't realize when those entitlement checks, Social Security, disability, military retirees, federal retirees, welfare recipients, when they don't come in, that's 100 million people on the streets looking for food and shelter. The way I look at it is this way. We're all on a bus together. And we're cruising down the road and Congress is driving this bus. State legislators, you're riding shotgun. We come up to a sign and it says, bridge out ahead. What does Congress do? They step on the accelerator faster, from 60 to 70 miles an hour. We say, Congress, did you see that? Oh, don't worry, we got it under control. Another sign comes up, says, bridge out ahead. We can see clearly the bridge is out ahead now. I ask you, state legislators, I asked you, I beg you, to hit the mercy brake and take over the steering. You have the power. You've always had the power through the 10th Amendment and through the Article 5 process. Please do it for your children, your grandchildren, and our country. Thank you.
Thank you. Mr. Moran, I think your calculations of spending is beyond what they have as income, not just their total spending.
$140,000 a second.
Beyond it, yes, sir. Yes, sir, you're next.
Mr. Chairman, members of the committee, my name is David Goldenshoe. I'm on your list there towards the end.
Toward the end.
And I rise to speak in favor of of Senate Resolution 371. Senate Resolution 371 is part of a group of items that are before you, or that will be becoming before you. You've already had the Compact for America, and you will be having Senate Resolution 736, which is the resolution supported by the Convention of States Project. I am affiliated with that as a volunteer of the Convention of States Project. All of these Article 5 proposals are so incredibly important toward reining in a runaway federal government. I know y'all are familiar with this resolution, having considered it last year, so I won't go into great detail on it. I would simply say that you will, of course, hear from the naysayers. If you haven't already, you will before the day's over. I'd like to speak to just a couple of points that we often hear from them. One is that Article 5 really doesn't say very much, and therefore we really don't know what the rules and things are going to be for Article 5. Well, the fact of the matter is there are more than 40 federal and state court cases, including a number of Supreme Court cases, that have construed Article 5 and have interpreted it. And they have said that in connection with Article 5, if we want to understand what it means, we simply go back to the founding era and look at the conventions and look at what the founding fathers' intent was. And if we go back, there are more than 30 conventions of states and colonies that were held in the founding era. So we have a very good feel for what the rules are, and we know that the states control the Article 5 process from beginning to end. They set, as you will be setting in 371, the scope of the convention, in this case to address a balanced budget amendment. You get to select the delegates. You get to require the delegates to take oaths. You can have penalties for those oaths. You can recall those delegates. And then ultimately, any amendment that such a convention would propose comes back to the states for ratification, requiring a minimum, not maximum, a minimum of 76 houses in the states out of a total of 99 to approve it for it to become law. So there are a huge number of checks and balances which our wonderful framers put in the Constitution that protect the Article 5 process. I will finish by simply saying we fully support 371. We ask that you give it favorable consideration, and that as well, when Senate Resolution 736 comes along, it's kind of complementary to it, that you do so as well.
We'll take that one too. Thank you.
Thank you very much.
Thank you, Goldenshoe. That's all we have, or you want to speak? Yes, sir.
Yes, Mr. Chairman. Kyle Jackson, State Director for the National Federation of Independent Business here in Georgia. Wanted to offer our full-throated support of this measure. Much like you all, small businesses have to live within their means, and we think it's long past time the federal government do as well. You've got a letter of support from my organization in your folders, and we would ask for your favorable consideration.
We pass that out. Thank you.
Thank you.
Thank you very much, Mr. Jackson. If that's all, we'll listen to comments from those who may be opposed to it. If you would come also up to the podium if you wish to, and we'll recognize you. Come on around and have them start. Give us your name and who you represent, please.
Thank you, Mr. Chairman. My name is Terry Green. I am the Vice President of Eagle Forum of Georgia. The psalmist said, because there's been a lot of references to those of us who oppose the Compact of States and the Convention of States, that we are fearful. God is our refuge and our strength, an ever-present help in trouble. Therefore we will not fear, though the earth should change and though the mountains be shaken into the midst of the seas. The RNC, the Republican National Committee, passed a resolution opposing a constitutional convention prior to the National Convention in Tampa on August 22nd, 2012. It was not part of the National Convention business. The resolution was also passed by the Georgia Republican Party in May of 2012. It read as following: whereas Article 5 of the Constitution of the United States authorizes the convening of a convention for proposing amendments, now frequently called a constitutional convention, on the application of the legislatures of 2/3 of several states, and whereas the Constitution is silent to the qualifications of the delegates to such a convention and how or by whom they should be selected, and whereas the Constitution is also silent as to the agenda of such a convention and sets out no way to limit the agenda and of such a convention, and whereas former U.S. Supreme Court Chief Justice Warren Burger concluded that there is no effective way to limit or muzzle the actions of a constitutional convention after it is convened, and whereas a constitutional convention would attract a multitude of individuals and special interest groups with agendas that would alter our Constitution beyond our recognition, whereas well-known Democrat members of the U.S. Congress are currently advocating a constitutional convention to introduce a number of amendments that would enshrine and effectuate their liberal agenda, and whereas the Constitution of the United States is a timeless document which, by limiting the powers of the government it created and guaranteeing the freedom and opportunity of the citizens for whom it was created, has produced the best and most productive nation in the history of the world. Now be it we, the Republican Party of the United States of America, resolved that we strongly oppose the convening of a convention for the purpose of proposing any amendments to the Constitution of the United States, for the reason that the risk of loss far exceeds the possibility of gain from such an uncontrolled and uncontrollable proceeding.
All right. Thank you, ma'am. We're going to have to limit. I prefer you wouldn't read. If you got something you want to pass out, we can get it distributed to the committee, but I want to try and get everyone a chance. We've got about 12 people back here, and time is going to be important. We're down about 3:30. We usually go to about 4 o'clock. So thank you, Ms. Green. Appreciate your comments.
May I ask a question?
You can present a question to me.
Okay, I know that there are two bills that are going to be dropped that are going to specifically speak to that they already are going to say, these bills are going to say that anybody who gets out of control in this convention will be arrested or fined, and those are going to be bills, I believe, dropped by Timothy Barr. Thank you.
Thank you. Next, you give us your name and.
My name is Jack Staver, and I'm here for myself. I'm here as a citizen of Georgia, and I'm a little bit puzzled, I guess, with a lot of this because I keep hearing that I guess most of you Republicans, I would assume. So the Republican committee.
Don't assume anything.
Well, I'm going to.
We got a mixture.
That's okay. I'm going to assume.
All
well,
right.
I'll speak to the Republicans in the room then. How about that? Let's do that. So the ones that are here, if you're a Republican, why would you go against the platform? Number one. Number two, in January of 2014, the 11th District Republican Party passed a resolution also asking not to convene an Article 5 convention. So that was done. Now, the other part of this that I'm looking at is I see all these things and I see what's going to happen, and I'm wondering, you know, we're going to have the governor pick the lieutenant governor and the speaker, the Senate speaker. Who are they going to pick? They're going to go down a phone book and pick names, numbers? How do we get picked? How do I get picked? How do any of these people in this room get picked? I really like to know that, because as in other committees has happened in the past, when leadership picks them, they're not citizens, they're people that are not have a different interest than we do. And I'm very concerned about that.
Understood. Thank you, Mr. Over. Next person, please.
Yes, Mr. Chairman, Lamar Wise. And I have nothing other than a few notes prepared here.
All right.
And I just, you know, I was walking in the rotunda before I came over here, and I saw there were, out of the 8 busts down there, there's 3 of them of men who attended constitutional conventions. Abraham Baldwin, who was a chaplain in the Revolutionary War, William Few, and Button Gwinnett, who attended a convention and died shortly thereafter. So it is maybe a dangerous sport. But one of the things that I was interested in is, and there were passionate people on the other side, especially the petty officer here, and I think Chief Petty Officer, excuse me, Chief, is very passionate about this, and no telling so. When I was a stockbroker back when Ronald Reagan was in power, and the nation hit $1 trillion in debt, and I thought it can't go on. However, they do have a Federal Reserve, and they have substantial powers, just as you do yourself in your committee in this body. So also one spoke of their trust for state government. Well, I've seen this in other hearings where, I don't know, I learned somewhere, somebody like Thomas Jefferson not to trust government. So to put our hands, if every state was to select the way that it's proposed for Georgia, with 3 officers of this state selecting 6 people plus 1, that's 120 people selected by 40 people for 40 states. It's not an action of the people, by the people, which seems to be the chief problem with the spending, and much else is done, is to somehow have the respect of the people and their rights, their natural rights, their unalienable rights. For whatever you do in your body or in a convention that may or may not happen, every time that you infringe on an inalienable right, which are 10 amendments to the Constitution do not cover inalienable rights. And the Constitution is like any other man-made document, not perfect. But I don't trust the process, and I don't look forward to anything that might come out of it. There are some boundaries in it. One thing that I would like to address about the delegates to be given an oath, it's similar to the oaths that are taken by the political bodies here in Georgia, Democrats, Republicans. Their delegates go into national conventions. They're supposed to be bound after a primary. Well, this is infringement on your freedom of expression, your freedom of conscience. There's no oath that can bind a true man or woman who goes to speak the truth in a body such as that. So the body will do what it wishes to do, which is, I hope, each one of you do. Whatever binds you might feel you have, always voting your conscience, no matter what the threats are against them. And I believe that kind of type of oath would be a threat on them. Thank you very much.
Appreciate your comments. Next, please.
Yes, I'm Dr. Bill Hudson, and I'm here as a citizen for myself. How did we get this national debt of over $17 million, plus trillions more in unfunded liabilities? Congress spent on objects of which it has no constitutional authority, such as teaching Chinese prostitutes how to drink responsibly, bailout of private businesses, welfare handouts, farming programs, education schemes, grants paid to states to bribe them into implementing unconstitutional federal programs. It was the unconstitutional spending which gave us this crushing debt. What should we do about the unconstitutional spending? We must eliminate pork. We must systematically dismantle unconstitutional federal departments and agencies, except that The Department of Education should be shut down and its bureaucrats sent home by 5 o'clock Friday. All these functions must be restored to the states and the people. This body of legislature finds itself not able to pass substantive legislation on a Second Amendment gun bill, allowing weapon carry in bars, restaurants, churches, property rights issues, college campuses without getting the blessing of the Board of Regents, and removing the governor from being able to confiscate firearms and alcohol under a Georgia state of emergency. Transportation bill, an improved transportation bill, Common Core total elimination from the state and local school boards, elimination of the state income tax and corporate tax, when all neighboring states have a more favorable tax situation for businesses and citizens, and movement to a fair or flat tax, i.e. consumption tax, without increasing taxes on various groups of citizens, thus not picking winners and losers regarding tax collection. And so now you want to ask this esteemed group to vote in an affirmative on such a risky measure which has little to no gain.
Thank you, sir. Next, your name and who you represent.
Thank you, Mr. Chairman. My name is Field Searcy. I'm here today to represent myself. I just have a few notes I'd like to read from, please. As I was studying the Federalist Papers last night, I marveled at the founders' knowledge of world history and human nature. Their vision and wisdom of the proper form of limited government was astounding. Yet for the last at least 100 years, we have lost that vision. Based on the current actions of Congress, I hardly think that the legislators of today have the same vision and understanding. All of our elected representatives have taken an oath to defend the Constitution. Many, I'm sure, carry a copy with them. Some are quick to whip it out and boast their reverence for its principles. Yet, precious few follow and vote according to those precepts. Congress has repeatedly violated their oath to support the Constitution. Consider the situation we find ourselves in today. Congress has exceeded its enumerated powers in all sorts of areas, exploding the national debt to over $17 trillion, not counting the unfunded liabilities, probably in excess of $100 trillion. They've allowed the executive branch to launch wars of aggression under the authority of NATO and the UN, as in the case of Libya. They've allowed the continued violation of the Fourth Amendment protections of privacy by not stopping the spying of the U.S. citizens by the NSA. They've allowed the executive branch to repeatedly change and make laws without any check, as in the case of Obamacare. We could go on and on. There are too many to name. And yet, where is Congress when all these executive branch usurpations occur? Where is the executive and judicial branch when Congress exceeds its authority? A balanced budget amendment doesn't address the unconstitutional spending that caused the massive debt in the first place. Passing more amendments will also be ignored, and worse, used to legitimize or legalize the status quo. What makes us think that Congress will abide by these new amendments? There are no provisions in the Constitution on rules that will be followed. The Convention will set its own rules. What special interest would want to control the Convention? Which states would not want to get more federal money? What kind of vote swapping and deal making would occur to give more authority to the government and take away liberties from the people? The reality is we are in a post-constitutional era. Unless the states force the federal government into compliance by exercising the rightful remedy of nullification under the 10th Amendment, we will continue to see the usurpation of the Constitution. We've seen the letters of Legislative Counsel warning that calls for nullification of federal laws is sedition and tantamount to treason. My fellow Georgians, this is just not so. On no less than 2 occasions in recent years, the U.S. Supreme Court has upheld the dual sovereignty of the states and the federal government. See Mack, Prinz versus USA, and also Justice Roberts' opinion in the Affordable Care Act. The real issue is whether the Georgia legislature is willing to refuse federal money. When accepting federal money, the state is beholden to federal authority. I'm sure that most of the proponents of the Article 5 Convention of the states, whatever you want to call it, have very good intentions. We're all sick and tired of an out-of-control federal government. A convention only delays the true remedy and is the dangerous move that could open up the entire Constitution. As the saying goes, the road to hell is paved with good intentions. We have the tool to stop overreach now. It's nullification. Please use it.
Thank you.
Thank you, sir.
Thank you, seriously. Yes, ma'am.
Thank you, Mr. Chairman. I'm Sue Ella Deadweiler. I publish Georgia Insight newsletter. I'm a volunteer down here. I monitor to see what you folks are doing down here so I can let the folks out in the state know. And I'm really happy to be one of those naysayers against this particular movement. And I'm in good company because in 2004, there was an independent bill introduced not to clean up the language, but to introduce a bill to specifically to rescind every call for a constitutional convention that this body had ever passed, and it passed. Also, I'm in good association with many of our founding fathers, our constitutional professors, and our scholars. I'd just like to briefly, not going to be very in depth with this, but Professor Christopher Brown, University of Maryland School of Law, the Dean's Office said, we already have 3 branches of government. Why create an unknown power to do even more mischief? And then Neil H. Cogan, Southern Methodist University, Dallas, said, my understanding of the Federal Convention is that it's a general convention, that neither the Congress nor the states may limit the amendments to be considered and proposed by the convention, that the convention may be controlled in subject matter only by itself and by the people that would then ratify the process. The convention may be controlled in that matter only by itself once it convenes. Jefferson Fordham of the University of Utah School of Law said this, a convention might propose a single amendment, but it would clearly have a wider range. Former U.S. Supreme Court Justice Arthur Goldberg said, proponents should be reminded that the Convention of 1787 was called for the sole and express purpose of revising the Articles of the Confederation, but they discarded the Articles and drafted the U.S. Constitution despite the Convention's limited mandate. And that was not an Article 5 convention. We've never had an Article 5 convention. Gerald Gunther of Stanford Law School said, in my opinion, a convention cannot be effectively limited, but whether I'm right or not, it's entirely clear that we have never tried the convention route, that scholars are divided about what, if any, limitations can be imposed on a convention, and that the assurances about the ease with which a single-issue convention can be had are unsupportable assurances. Now, just briefly, this is what they've all said. An Article 5 convention has never been called because it's an unknown power. Its subject matter can be controlled only by the convention itself and the people of the states, and that through the ratification process, not through a convention. Once a convention begins, state law will not prevail over the actions or the outcome. Regardless of well-intentioned restrictions, the convention would create its own agenda, and whether or not it's called a runaway convention or something else, it could completely revamp the current Constitution. Yes, that's dicta. But dicta is all there is. Apart from Article 5 itself, no matter what anybody says, it's still dicta. Thank you very much.
Thank you, ma'am. Next, please.
In August of this year, Phyllis Schlafly called me and asked me to be state president of Eagle Forum.
And your name?
Chris Owen, sorry.
Chris Owen. Thank you, Ms. Owen.
And since then, I've been out of my comfort zone, and this is one of those occasions. But I am adamantly opposing SR 371. I ask you to oppose efforts to call a constitutional convention or a convention of the states. Randy Burnett, an attorney and author of the Article 5 repeal amendment in 2011, acknowledged in his Wall Street Journal article dated September the 16th of 2010 that he wanted a runaway convention. On page 16 of the Liberty Amendments by Mark Levin, he explains, Robert G. Natelson, a former professor of law in the University of Montana, an expert on the state convention process, explains that a convention for proposing amendments is a federal convention. Even if the Convention of States organizations obtain everything they want, why would members of Congress adhere to new amendments to the Constitution if they disregard the present Constitution? This makes no sense. I'm asking you to please vote no for SR 371. Did you know that Georgia receives 38.6% of its state budget from the federal government of Georgia, federal government? If Georgia really wants the federal government to balance the federal budget, then Georgia should send back all federal money coming to Georgia. Are the representatives in Georgia willing to refuse the federal money and any mandates attached? Unless they are, an application for the Constitutional Convention for a balanced federal budget is a sham. Article 5 does not limit a constitutional convention to one subject, but states for proposing amendments. There is no way to limit an Article 5 convention. Please don't fall for risky efforts to improve our Constitution. Our problem is not our founding document, but with the people that we elect.
Thank you, ma'am. Appreciate it. Next, please.
Thank you, Mr. Chairman. My name is Carolyn Garcia. I'm here representing myself along today as a citizen and a very concerned citizen. I went back last night and briefly just refreshed my memory about the Articles of Confederation. A lot of people are not aware that that was the first Constitution that we actually had, and they proposed this and put it together back during the time that the Revolutionary War was going on. They didn't have the last state ratify, and that was Maryland, until 1781. And there was a lot of conflict and controversy at that time. There was a lot of things wrong with the Articles of Confederation that they soon learned after the ratification. That one, they said it was too weak of a national government, and I'm not so sure that wasn't the correct thing in that particular instance. But they took another 6 years until 1787 to actually do a constitutional convention. In that process, while they were talking about this and finding all the problems with Articles of Confederation, they learned that there was a lot of things that was being offered. One, the Northwest Ordinance. Two was the Virginia plan. Then there was the New Jersey plan. One plan had a unicameral legislature, just like the Articles of Confederation did, and the other one had where we had our present Congress, the way it's set up. There was a lot of conflict, a lot of people, and the reason that the Articles of Confederation didn't work at that time is because there was no real plan in place. They tried to do what they knew to do to have a government, and the states became their own individual sovereign nation, basically, and was fighting among each other. They began to realize they needed a constitutional convention to fix the Articles of Confederation and fix all the things and flaws to try to make a good government for our United States. And in 1787, they came together. Were they all in unison on what they wanted to get done at that time? No, but there was persuasion. And I want to just briefly mention something. You know, we have very good people. I personally know a lot of these people who are proposing this and standing for this and want to get a Article 5 convention. These are good people. They're excellent people. And we probably agree on 99% of everything else except for this issue. And people can call me a fearmonger or whatever. I'd rather side on the air of being cautious than I would to go forward into something. When they took from 1781 to 1787 to look at what was wrong and then decide to come together for a constitutional convention, I think this is an issue that we should not take lightly or run into. And I will close with this. We have runaway spending. My grandchildren will be indebted forever, and their grandchildren will be at what we have today. We understand that. But before I read this last thing, this is what I feel about the present Congress and any one that's been before this. If we cannot trust the President and our Congress to follow our current Constitution and its amendments and the budget process that was put in place by our longstanding Constitution, how are we going to believe that they're going to abide by any other Constitution that might come along? Now, the one thing I want to say about the spending is that this goes all the way back to the Articles of Confederation.
What are you reading?
Very, very short, about 4 lines. Just basically what it was about the Continental Congress, they had paper money, and they were financing this, and you've heard the term not worth the Continental. Well, what was happening after the war, and they wanted to anticipate how they were going to get the taxes, they kept printing money and printing money and printing money. And it was just building up the debt and building up the debt and building up the debt. And Madison said he referred to this as the mortal disease of government. Yes, runaway spending is a terrible thing, and we got to put it under control.
Thank you, Ms. Garcia.
Not this way. Thank you, sir.
Yes, ma'am.
Yes, good afternoon. Carolyn Cosby. I'm chairman for the Canton Tea Party in Cherokee County. I'm good friends with most of the people in this room, whether they agree with me on this issue or disagree with me on this issue. And I'm hoping when I leave this room, we can still be friendly and agreeable.
Hope you're right.
I do too.
All right.
This issue is a little bit like this budget issue is a little bit like a woman's grocery cart in a Walmart shopping center. You can jam all kinds of things in there that aren't milk, butter, and eggs. And that's what we can do with a budget. We know all too well what happens in our local counties when they start writing bonds. And so balancing budgets is really not what I think most Americans think it's like for governments. It's not keeping a checkbook up to date. We have many, many creative ways in government of spending money. So the idea of a balanced budget working, I think, is very iffy. I agree with the speaker before me that if we can't obey the amendments that we have now, how are more going to help us? What gives the law strength and power is that people believe in it and they're willing to obey it. As has been said, the just powers of government are derived from the consent of the governed. In my Tea Party, if we have an important decision made, and we have this in our policy statement, we require a 2/3 vote to go forward. The Tea Parties are deeply divided on this. Now, I realize that may not cause many of you on this board much angst. But the Republicans and the Democrats are deeply divided on this. Many, many groups out there are deeply divided. And when you have this kind of concern coming from all different directions, it's a good idea to step back and let cooler heads prevail. And I would recommend to you that you delay this for at least another year and allow people to do more thinking and considering and see if some agreement can be had. After all, going forward, we're going to need it.
Thank you, Ms. Cosby.
Thank you.
And our last speaker. Thank you.
Thank you. Mr. Chairman, I'm Robert Bryan, a resident of DeKalb County, a citizen of Georgia for 62 years, and I would like to arise just to appeal to you and the other committee members to oppose moving forward this particular bill because I'm concerned, my motivation is about my own natural rights, my own inalienable rights, those of my children, my grandchildren. And I fear that despite the good intentions of those who want to rein in an out of control government, and one that is abusive of the will of the people and is unresponsive and is not keeping its oaths of office to us to listen and follow the will of the people, that we're not going to see, despite their good intentions, what really needs to be done, and that is the people holding elective office now to do the right thing and to quit trying to claim the property of the citizenry to do things the citizens do not want. Overtaxation, overborrowing is threatening, the future of not only my family but every family in this nation. And I feel that our present administration of government is hostile to the Constitution, and that their attitude is unlike that of the founders. Their worldview is hostile to a constitutional form of government and to a Republican form of government.
Thank you, sir.
And I just appeal to you, sir, that even though Washington in his farewell address said if it is the opinion of the people to modify, that they should do it through the amendment process, that all of those like Madison cautioned against that particular method, when the real matter is the people in office now should be restraining and controlling themselves, moderating their behavior and their desires to continually spend the people's money or to borrow against the debt and the good credit of the United States.
Thank you, Mr. Bryan. That being all the speakers, the chair will close off further public input, comment. Senate resolution, is now before the committee. Is there any comments from any committee members? And we have 29. That Mr. Lindsay.
Thank you, Mr. Chairman. I have friends in the audience on both sides of this issue, and so it is somewhat difficult to look at them and to recognize that I'm going to disappoint at least half. But here are some facts that we cannot ignore. As was expressed earlier, the constitutional amendment on a balanced budget was introduced during the Reagan administration. In 1982, we crossed over $1 trillion in debt. No constitutional amendment. In 1986, we crossed over to $2 trillion in debt. No constitutional amendment. 1992 crossed over $4 trillion. No constitutional amendment. 2006, $8 trillion. And today we have a national debt of well over $17 trillion, and yet no meaningful attempt by Congress to rein in out of control spending and to pass a constitutional amendment to balance the budget. The fact of the matter is, if you look at the amendments to the Constitution passed by Congress over the last 200+ years, they've never restrained their own authority or their own abilities. And the fact that, and for that reason, we have no choice but to have the states act today. We have waited patiently for Congress to act, and I've heard my friends ask that we wait for more. We've waited long enough. To do nothing is tantamount to surrender of our nation's long-term economic health and social well-being, and to subject our children and grandchildren to the debtor's prison caused by the folly of this generation if we continue to do nothing. And for that reason, Mr. Chairman, I'm going to move to do pass at the proper time.
All right. Any further comments from any member on the committee? If there are none, no applauding, please. If there are none, the chair will now entertain motions on Senate Resolution 371. Is there first a motion to pass Mr. Lindsay's motion, seconded by Mr. Welch? All right. Any discussion on the motion? No discussion. Are there any amendments? There are no amendments. The chair will call the main question. All in favor of a do pass Senate Resolution 371 signify by saying aye. Aye. Opposed, like sign. No. The chair rules the motion carries. Thank you for everyone's input and time spent on that particular matter. The next one, I'm sorry, Mr. Alex Atwood, I overlooked your other quick bill, and I apologize. Appreciate your waiting. I hope you got a good education on constitutional amendments today. If you want to speak to the committee on House Bill 890, which is a very simple thing.
I did, Mr. Chairman, and it was very, very interesting. I enjoyed that.
Let's keep the noise quiet, please. Let's
Members
take
of
the
the
noise outside for talking conversations. Take the conversations outside the room, please. We're still conducting business on the committee.
Members of the committee and Mr. Chairman, I ask for your favorable consideration of House Bill 890. This goes in tandem with the previous bill 776. It is again some cleanup language in the Jury Composition Reform Act that we passed back in 2011, and all it does is add back existing law that was, I don't know how it happened, but was inadvertently struck, and that was a 7-year work by many, many people, but was inadvertently struck. And it says this, and this is exactly what the sheriffs are currently doing, and it just adds it back. And that all counties in the state where the sheriff is paid a salary only, this code section shall apply as far as any fees to be charged. And what we're telling the sheriffs to do is turn the fees over to the county treasurer or the fiscal officer of the county. They currently get paid for serving papers and that sort of thing. Just take the money and put it back to the fiscal officer of the county. And that was past law. We're asking that it be made again current law. I've received no opposition whatsoever. Sheriffs are currently doing it already.
Have you heard anything from the sheriff or sheriff's association?
Sir.
Okay.
Not one way or another, but they are currently.
They're aware that's what they're doing it anyway. Correct.
Yes, sir. And I have Ms. Nesbitt. I think she's still here with the ACCG, and they've asked for this.
Any questions of members of the committee of Mr. Atwood? If not, we thank you for being here. Anyone else wish to speak on House Bill 890? No other comments? We'll cut off further public input. The bill is now in the Breast Committee. Any comments from members of the committee? There being none, the chair will entertain motions. Have a motion to pass. It's been seconded. Any discussion on the motion or any amendments? There being none, the chair will call the main question, which is due pass motion to House Bill 890. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. The last bill is one that Mr. Martin was to present, but he's not going to be able to attend, so I'm the second signer. I will do so, and I would ask Mr. Fleming if he would preside over the 21, yes, sir, over this particular part of the meeting.
House Bill 819. Mr. Chairman, you want to proceed with presenting that to us?
Thank you. I will. The bill is a matter to address the primarily the issuance of what we call tax execution or tax liens through the failure of individuals to pay their property taxes in a timely manner. And when people do not pay that tax in a timely manner, they subject their property to potential tax execution, and that can ultimately go to the loss of the ownership of their property. So we do recognize the strong need, obligation for these people to pay taxes. We also desire to have within the law of our state some measures that will be certain to, where necessary, protect them from misuse of the process. And if you look at the bill, the first thing you have is under section 48-3-3 is a definition of due diligence. And this is a describing the things that are to happen prior to the issuance of a tax execution, and the fact that the bills may have come back. I know that in the past, whatever the practice may have been, but bills will be sent out by a tax commissioner's office or tax collector. The bill comes back, it goes into a drawer, and nothing really further is done about attempting to see what may have happened as far as there being a sale of the property, a change of ownership, matters of that nature, so that you have a means by looking into information that's available to a tax commissioner, find out if in fact the ownership of the property has changed or something else may have happened. So all we're speaking of here is when there is a potential tax lien on the property, that there will be a need to have what we call a due diligence, and that diligence speaks of, you see, checking telephone directories, the county where the property is located, checking internet search engines of people, finder databases, which may include the use of online address verification products and services, checking the records of the tax commission of the county where the property is located. or check the real estate records of the clerk of the Superior Court of the county where the property is located. We're seeking there just to say do something more than just have the bill come in back to your hands being unpaid and not going forward with a review of the matters available to you as far as potential search locations for that person's either location or the fact that property has changed hands. Further on page, the rest of it you see is the language as it stands on second page, paragraph 2 and paragraph B. C has a slight change, which is as soon as the last day for the payment of taxes has arrived, the tax collector or tax commissioner shall perform the due diligence search in effort to obtain the delinquent taxpayer's correct address or any new owner's correct address in order to notify in writing that taxpayer of the fact that taxes have not been paid. Unless paid, an execution will issue. So there again, we're looking at the direction to the tax commissioner to find out if they can why the person did not receive their tax bill before that execution goes out. Under paragraph D, no execution shall be issued against any person who is not the owner of record of the property on the day that the taxes become delinquent if, within 90 days of the due date, such person has provided satisfactory proof to the tax commissioner or tax commissioner that the property has been transferred by recorded deed and the liability for the payment of the ad valorem taxes has been assigned to the vested transferee by a written agreement or contract. We also speak down here the notice provision. It tells that in such cases the execution shall be issued against a person who is the new owner of the property on the date the taxes became delinquent only after such new owner has been sent a notice of the delinquent tax bill, and such notice shall state the tax commissioner or tax collector intends to issue a tax execution. So again, we're trying to keep notice to the parties about that. This is all part of what we call the due diligence to help try and protect those who may be harmed by a wrongful issuance of a tax execution. Under Section 2, what we're addressing here is the fact that a tax execution after being issued cannot be sold or transferred to a third party until at least the end of the calendar year. It says, but not until the next calendar year. So if you had a tax due in 2013, you could not, and the taxes really become due sometime in October, in most cases November, and as late as December 20th. So if they're issued, and if they have not paid and a tax execution may issue, they've got to wait until the calendar year, following the calendar year in which the tax execution was issued, and not until at least 90 days after of time has elapsed. So we have two measures. We have the end of the year, or at least 90 days, if that extends it beyond the date of January 1st. And the point there being, if the tax comes due, say December 20th, there's got to be a 90-day spread before executions will be able to be sold. That means transferred by the tax commissioner to a third party's hands. We have found in the past but abuses we think that have occurred with the transfer of these. And part of the problem you have is the fact that if it's done earlier, there is a loss to the counties of what is known as the penalty for the failure to pay the tax. And that penalty amounts to a 10% penalty. So when you have this execution transferred in an earlier date, the revenue of that penalty is lost to the county and is gained by the third party holder of the tax execution. It is the belief of many of us that the tax penalty should be something that rests with the county prior to the transfer, and that's why that particular date is put in there. We also have the rest of it in the section, let me back up, excuse me, section 3 is again dealing with the redeeming of the tax execution. And all we're doing here is striking out some language and putting in legal or equitable title. It says whenever any real property is sold under or by virtue of an execution issued for the collection of state, county, municipal, or school taxes or special assessments, the defendant in 5 faith or any person having, it used to be right, title, or interest property, say we now change to say legal or equitable title in the property may redeem the property. And this goes to something we'll have, I believe, a person speak to in a minute about the what we call super liens, which is going to be addressed in Title V. But under Section 4, if you remember, there has been, in the circumstances of the Fulton County Tax Commissioner, the receiving of a 50 cents fee for every tax execution issued. And this goes back to a period of time in Georgia where you had most of your local constitutional officers on fee system, whether it was sheriffs or tax commissioners and others. And this was a holdover from that language, and our tax commissioner in Fulton County found that. He made profit of it, really, I think, improperly, but that was the way the law is, and therefore he received a fair amount, several thousands of dollars each year on these tax executions that he just issued and got a 50-cent fee because of it. Now, that takes out that language, so there's no longer that right. That's what it does. It removes that right. Section 5 deals with the area that I'm talking about. I believe is the special, call it tax liens, or called dealing with the, where you have a tax execution issue. There's also some other outstanding judgment. I think there's some people here from the bankers industry that can speak more properly on this point. I'm trying to see, where are they, if I could call upon them. Elizabeth, come up, please. Yes, sir. There you are. I'd like for you, if I may, Mr. Chairman, have these individuals speak more about this, what I call super tax lien issue, because it's been used by those who are trying to gain the system as a way of getting extra income, earnings, we'll call it, off of the buying and selling of not only the tax executions, but also finding a judgment in the records where they buy that up and then can go through a full foreclosure at a quicker, accelerated manner on the entire property.
Thank you for coming today. Please introduce yourself, tell us who you are and who you're with, and welcome.
Thank you very much, Vice Chairman. My name is Kevin Waters. I have my own law firm in Sandy Springs. I'm a solo practitioner. I am here because I had a Mr. Young reach out to me recently. Mr. Young is a citizen of Gwinnett County. He's 95 years old. He had paid for his house, and he worked hard his whole life to pay for his house. But as with many things, age takes a hold on your mind, and sometimes family isn't as close as you like. And the next thing you know, the taxes don't get paid for a couple of years. Then one of these, a collection company, will come in and buy a lien, buy the tax liens. They'll go through, start a foreclosure process. They'll foreclose on the tax lien, and at that time, you would think, okay, well, there'll be a tax sale. Mr. Young would get the excess funds from the sale, or he could pay a 20% penalty under the current law. But this is what happens in reality. The same collection company, through a different entity, buys another lien. They'll come in with two liens, and this gets back to the super lien issue that Chairman Willard was referring to. They come in and they have a right under this law to also redeem the property for a 20% penalty. They redeem it almost immediately, which now gives them, so let's just say it's $100,000 was the tax sale amount, and there's a 20% penalty. So they've now redeemed the property for $120,000. And under this law, they get what's called a super lien, which is ahead of the mortgage and it's ahead of all other liens on the property. They get the lien then, through their the second tax lien that they own, have now gained a super lien on the property. Now, my client discovers, this is about the time that you will discover this. This is where these elderly and sick people, this is usually who this happens to. And I just want to make clear, I'm not here, although I am a member of the Georgia Bankers Association, I don't do a significant amount of work for banks anymore. And I'm not being paid to be here. I'm here because of my client, and because I felt like an injustice was worked on him. But the super lien, let me get back to this. It's important. So now this same collection company, through a different entity, has a super lien for $120,000. They, through another entity, had paid $100,000 in a tax sale. Well, guess what they do? They immediately claim with that super lien the excess funds from the tax sale that they just bought the property at. So everything in excess of the taxes, they take back. Then, when my client goes and says his family discovers, oh, the taxes hadn't been paid, obviously we'll have to pay some penalty. Obviously, you know, we're happy to do that. Well, the penalties are $20,000 plus attorney fees plus other fees, and so you're looking at almost approximately $30,000 in fees by the time you get to it. Luckily, my client had a family that was able to come up with the money to save the house. But as you can imagine, most elderly and sick people in Georgia don't have access to those type of funds. And I imagine that every one of the members of this committee has elderly people in their districts that may end up having to deal with this at some time. And that's why I'm here. Because we're not saying they shouldn't have to pay a penalty. Obviously, you don't pay your taxes, you've got to pay a penalty. But 20%? And let me tell you, explain that you're saying, well, there's tax sale. Well, guess who's picking it's a system. It's been created by a certain set of companies that have found a way to game the system. And so when they buy these liens, they'll go in and they will bid a higher amount at the tax sale because it doesn't matter because they're getting their money back on the back end through their second lien. So they will bid far in excess. So even if the amount owed in taxes was $5,000, for example, in the example I've been talking, they may bid $200,000. So that when the citizen in your county goes, or in your district goes to redeem it, the fee's $40,000. The tax bill may have only been $2,000 to $3,000, but now they're being forced to pay $30,000, $40,000 to redeem their property, or lose out on the total amount of equity they built out through their whole life. And that's what's been going on. And no one is benefiting except for this small group of collection companies. And no one is saying and I assisted with adding some of this language, and like I said, I haven't been compensated, and I'm taking a day off work today, and I'm behind because of the ice like everybody. But what this bill does is it still entitles someone that buys a tax deed to a fair return. Instead of getting 20% on the amount they bid at a tax sale, which they're choosing, which leads to people inflating the tax sale price, they get 20% of the tax lien they bought. If the tax lien was $5,000, they get a 20% return on that lien. That's a pretty fair return in this market. I'd take that.
Isn't it also true, may I ask, Mr. Chairman,
Mr. Chairman.
Isn't it also true what happens with this procedure you're describing is taking away the right of redemption under that tax execution, which you have 12 months in which to redeem it before the property can go through a foreclosure?
Chairman Willard, you're right on. That is exactly another major problem. The law generally allows a 12-month redemption period. But as soon as these collection companies through a separate entity come through with their second lien and redeem the property goes back to the property owner's name, but it now has a $120,000 super lien on the property, in my example. And so the 12 months is gone. And then they can immediately initiate a foreclosure proceeding, and unless that person can come up with the 20% penalty, which if on $100,000 to $20,000, but they can bid a lot more than $100,000 oftentimes, then they're gonna lose their house, and they're gonna lose all the equity, and it's just not right. No one is saying that these people who buy these liens, we need to sell liens. Liens have to be sold. I mean, it's part of how counties generate revenue. And
I'm sorry, go ahead.
And
we got some questions.
Oh, I'm sorry.
Sure.
No problem. Number 25.
Who's number 25 down there?
Actually, my question was to you, Mr. Chairman.
Yes, sir.
It was just a matter of clarification. I know you said that the bill speaks to not being able to sell the tax debt for a 12-month period, but as far
they sell it. As far as the tax execution, the tax execution would issue either immediately upon failure to pay the taxes, frankly, but they can't sell that tax execution until after the first of the year.
Right.
That's what.
But the question I had, in terms of the due diligence part of it, Does this bill speak at all to being able to third party out the actual investigation? And the reason I'm asking that question is that I can see deals being cut, farm out the due diligence piece of it, and then after they've done their due diligence, now they become the collection agency. That's why I was asking the question.
I've quite followed your question there.
You have situations where what you're describing is that if the bill passes, that they would have to do
Third
due
parties,
diligence.
who owns that, who now holds that tax execution, would they have to do that same due diligence?
Well, that's one. I wasn't thinking that, but what I was really thinking was would the office, the tax commissioner's office, would they be able to farm out to a third party the work associated with the due diligence, not with the collection?
Yeah, I'm not sure how they would farm it out if they haven't sold the tax execution. I mean, maybe they could contract with somebody and say, you do this work that needs to be done. We don't have within our own office the means of doing it, but yes, they could find somebody to do that.
And I'm wondering if the collection agencies would now have a new revenue source, for lack of a better way of putting it.
That's up to the tax commissioner, I think, making that decision, and I guess assuming they had revenues appropriated for that purpose by the county.
Yeah. We have further questions.
Number 27, I believe the next one.
27.
Mr. Chairman, this also is a question for you, and it's somewhat similar in the vein of what Roger was talking about, and I made a note when you were going through this concerning the due diligence is, in my opinion, it would be within the office itself. But my question is, who's going to do it, and then are they going to have to certify through some document where you say an affidavit or something, what we did?
Yeah, I think
so that that's not in here.
I think what you'd have, Judge, if somebody raised that issue that did you do a due diligence, because we owned the property, it was maybe transferred to another person, but we've got records where we're still owning property in the county, and you didn't at least look at your own deed records or the tax records. I think if it became a factual issue of what did or did not occur, they could show by testimony in court or otherwise, as you know, this is our procedure, we're following what the law says, and we use these means or mechanisms of going through trying to locate the person. We can do a search by our deed records, we can do a search by our tax records, we can look at the telephone directory on white pages and find out if the person's listed there. I've had people I have not been able to find normally, but radio and start going to white pages and type in their names, and they may be formerly living in Decatur, Georgia, now living in Stockbridge. But I find them that way, easy enough.
Well, I guess my question was, I was just thinking maybe we should put in that they should do these things, and then somebody certifies that they were done.
Yeah.
Or at least tried to do them.
I think that'd be my personal thought on judges, it'd be a matter of their proof when called upon to show what did you do or not do in seeking to resolve where this person who has not paid the tax.
I guess you could cut it off at the beginning, though, if you did this, and that could never be a problem with it.
True.
Chairman Weldon.
Thank you, Mr. Chairman. If I could address this to the speaker. In your example you gave, I think you started out and you said that a person allows their taxes to not be paid for a period of 2 years. Is that correct? Is that part of your explanation in your
Yes, Representative Weldon.
And then they get the first lien, they go in there and they pay for the first lien. That's for the first year that they didn't pay. Then they go along there and they don't pay the second year, then they buy that lien also, the tax lien.
Well, and usually the counties don't sell the liens right away, so they're sold in bunches. And so what you see is these collection companies are looking for these type situations. They're looking for getting 2 liens or 3 liens to where they can do this process. And so, if you will, they're preying upon homeowners that they think are susceptible to these situations. And so it's usually not executed that quickly, in my experience.
And I guess I have a, and you also mentioned that nobody's benefiting from this. The county has gone without 2 years worth of lien revenue, and then that comes back to schools, that comes back to the other taxpayers in the counties that are paying their taxes on time. They have to deal with that loss of tax revenue for that piece of property. I guess I'm not sure I'm clear on, who's not, that there's not someone benefiting. I think your point in that that you feel like that there's been some people that have been preyed upon, but there's also been some detriment in the county and then potentially a municipality, but they're benefiting by getting the tax revenue they didn't get in the first place, and that's 2 years late.
No, and Representative Weldon, I would agree wholeheartedly with you if these fees were going to the counties. But this 20% fee that we're altering here doesn't go to the counties; it just goes to a collection company.
Mm-hmm.
And so what we want to do is not create a process to where no one will purchase it.
Right.
May I also add to that discussion? It's not just tax execution. There will always be a tax execution out there, but it could also be a lien that has come about from even a credit card failure to pay, and they've got a judgment on that and it's put on record. And they use that as the other lien means to now cut off the right of redemption through that tax execution.
So they foreclose on the judgment lien. Okay,
That's right.
I see what you're saying now.
That's what happens.
And I'm sorry if I made it seem like it had to be another tax lien.
Yeah, it doesn't.
But one thing I do want to point out is this is actually hurting the counties, because I have spoken to at least one tax assessor, and they've told me they have stopped selling tax liens, which they would love to do to get the tax revenue in, because they're sick of the way this has constantly, they're getting calls from citizens and they can't do anything about it. They don't own the liens anymore. And so by having such an excessive penalty, not a penalty, but an excessive penalty, you're actually discouraging counties from wanting to sell their liens, because they don't want their elderly taxpayers calling and say, I just realized I need to pay my taxes. And they say, well, call this company, and you're going to end up owing them 10, 15, 20 times what your taxes were.
If I may, Mr. Chairman.
Sure.
But there has to be a way of, and I see what the bill does here, but I'm not sure I wholeheartedly agree with the characterization of the status of our law at this point. I've handled these situations for other people, and they were just people who wasn't going to pay the taxes. And it's not just elderly folks, and I'm not saying that doesn't happen to them, but this will, cause there to be less concern about not paying a county tax bill among those who would try to stretch it out or not pay the taxes on time.
Well, I think that I can see how that might be the case, but I think that the important thing to see is that these taxes, or the tax liens, are going to be sold by the county likely when they're not paid. They're going to be sold by the county at whatever price. And
Okay.
so, in fact, if anything, this will allow the counties to go forward and sell the lien. Now, the person who's not paying their taxes, maybe their penalty will be less on the back end, and maybe there's some people that will go that far of calculating and whether it makes sense not to pay taxes and risk losing their property. But what more than often than not in my dealings with these and seeing this is it's not people who are not paying their taxes because they're just not going to pay their taxes. Those people aren't going to pay them anyway. The liens are going to be sold. There's going to be a foreclosure, and it's going to go forward. It's either one of two situations. The situation I described, which was my client's situation, or a situation in which a bank has a mortgage, and that's why the Georgia Bankers Association is interested, because they lose their complete mortgage rights to the property.
But that's only to the tax lien. That's not to the it's not necessarily to the judgment lien.
Well, the judgment lien is just a right to redeem. So anyone with a judgment lien can redeem the same as a tax lien. So as soon as the tax lien is executed upon, anyone with a lien under the current law can redeem the property by paying the 20% penalty.
Let me add to that, May, if I could,
Sure,
Mr. Chairman.
absolutely.
Two things. This is only going to occur where you have a tax commissioner selling the tax executions to third parties.
Mhm.
There's only, I think, right now 2 counties that are doing this as a practice, 2 large counties. There would then also have to be something, as I say, this other lien come about as a judgment on record for anything. It could be taxes, other taxes, it could be anything else, where they buy that lien from the holder of it and then are able to do this, what I call end run, that permits them to go through the foreclosure on that without going through the normal tax notice redemption rights. And that's what we're trying to stop is happening, because that's where the people get hurt, is that you don't go through a tax redemption period of a year and then a notice provision as you have to do with the tax lien.
Okay. But before they get that lien, doesn't there have to be a lawsuit filed?
No, sir. That's what I'm saying. They bought a lawsuit. It could have been, say, for a credit card debt. I'm just using that as an example.
Okay.
Or it could even be another type of public utility that has a right to take a lien under law for failure to pay. A garbage lien could be an example. So you didn't pay your garbage, you've got a lien right through your local city or county, and that's put on record, and they acquire that. Whatever it may be as far as 2 liens is how it works.
No. And Representative Weldon, I think that one of the problems I've seen that I would hope to address through this bill would be that, and I asked a lot of attorneys in this area, and I kind of got their input because I don't think I know everything. And they said the real problem, one of the biggest problems, is this 20% penalty. Because when they do that, when the company that buys the lien is usually the only person bidding at the tax sale. And when they know they've got a 20% penalty coming, they intentionally bid a much higher number than they would bid otherwise to increase that 20% penalty, knowing that they've got a second lien, whether it be a $30 municipal lien or a $70 credit card lien, that they're going to immediately redeem the property, get everything back except for the taxes, and then when the property owner comes back and says, oh, I just realized my property taxes, whatever happens, I want to redeem my property or I want to pay off the lien, they're going to owe 20% of whatever the collection company chose to bid. And see, this, as the bill is now amended, that now is defined based on the lien being levied, as opposed to whatever number they choose to bid in at the tax sale. And that's where I think that you'll see the Bankers Association. I know this because in my past life at a big firm, years ago, I've seen banks deal with this issue, where you'll have a property that might be worth $150,000, and the collection company bid $400,000 on it because they know the bank's going to come in and pay an $80,000 penalty because the property's still worth more than $80,000. And this is really the only people greatly benefiting from the law as it is now written is these collection companies.
And I guess I take a little bit of an issue there, because that when that happens one time in Catoosa County, and that will reverberate through the entire county, Walker, Whitfield, and everywhere around there. And then when December 20th comes around in Catoosa County, you'll see a big line right out the door at the tax collection, and everybody's paying their bills, or else they send it in earlier, because they know there's a consequence to not paying your taxes. And that's, I think I see your point, but I'm just concerned about there not being that pressure, that stick for folks.
And I think we're not trying to take away the stick with this amendment. I think we're just trying to make it a smaller stick. Because right now we're using a sledgehammer to kill an ant. And what happens is when someone does this, what happens now is when the situation does arise where someone makes a mistake or there's a mishap, the fee is so far in excess of the taxes owed. You know, you may have $2,000–3,000 in taxes and $30,000 to redeem, versus, I mean, that type of penalty, if it was put in, you know, I was just thinking there was no way that you would see the state charge that kind of. I'm sorry.
No, just keep on. The point I'm trying to show is there's two different kind of penalties we talk about here. Failure to pay the tax, you get automatic 20%. Boom, that goes on there. This is now going toward the failure of the redemption part of it, where you, if you read this section 484-42 under section 5, the code section, you have the special assessment of the property plus a premium of 20% of the, used to be read the amount for the first year of a fraction year thereof that elapsed between the date, that is as to the sale price, not as to the tax lien. We put in there now as to the writ of FIFA upon which the levy was made. So we limit it to that being the penalty on that writ of FIFA, as opposed to the amount that totally bid in, try to bid on the property to run it up to acquire that super tax lien. So there, the 20% for the 10%, excuse me, for the failure to pay the tax, and now you're talking about back in the time of redemption, these other things get added in, as well as 10% for any fraction of a year.
All right, any other questions, Chairman Walden?
Sure. If I could pose I think I have a same question or similar question that Judge Caldwell posed in lines 16 through 26. My question on the due diligence issue is I guess it's the same one, very similar to what Judge Caldwell says. How is the requirement when you have the due diligence requirement? If the notice returned undelivered, the following actions shall satisfy the diligent search requirement of this code section. And then so is that a conjunctive in those actions, or is it disjunctive?
I would look at something.
I guess on line 21, after it said the diligent search requirements of this code section, colon, then it says checking phone directories for the county wherein the property is located, then checking internet search engines and people finder databases, which may include the use of the online address verification, products and services, checking the records of the county commissioner.
We could add in there examples of such effort would be da-da-da-da.
Okay, and then that would be, okay. All right. Thank you.
All right, Representative Lindsay, you had questions?
First off, a brief comment. I feel like I'm in Groundhog Day. You remember the movie? Because these bills come up every single year. And, you know, coming from Fulton County, there's a reason for that, because we're one of the two counties that practice this. And they do so for a practical reason, in that by doing so, the counties and the school boards and the local governments get 100% of their taxes paid for them to operate, and then they turn over the collection to someone else. The balance has always been, you know, trying to protect the rights of the property owner versus the needs of the county or the local governments to have a stream of revenue, and quite frankly, to not burden the taxpayers who are paying the taxes on time with additional taxes caused by folks who aren't. So I have a couple of questions, Mr. Chairman, and along those lines. And I understood, you know, in one place you talked about the fact that the person who buys the liens now gets the penalty instead of the county. Does the county get the penalty if the county were to hold on to it? I mean, if
Good
the tax,
question.
let me
Good
ask,
question.
if the tax commissioner were to hold on to it and try to collect himself, does the county get the penalty? Or let's just say, for instance,
Yes.
the tax commissioner is collecting a tax for Sandy Springs, hypothetical city. Does Sandy Springs get the penalty, or does the county get the penalty?
Good question, and I'll tell you what happens as a practical matter. The tax commissioner in Fulton County will sell the vast majority, the big bulk of his tax liens, tax executions, prior to January 1, in order that the transfer of these tax liens, when they incur the 10% penalty, will be after the first of the year, and that would then go to the third-party holder of the tax execution.
Yes, sir.
We're suggesting that it is not proper to have the county lose the right of that stream of revenue, the penalty, because they're the ones that had the tax that was owed and failed to be paid. And what we're suggesting is before they sell these tax executions, they wait until that penalty is incurred. And then if you look on the page 3, the lines 81, 82, and 83, 84, it says, but not until the next calendar year following the calendar year in which the execution was issued, and not until at least 90 days have elapsed from the date of the taxes were due, because that varies from location. And then it goes on to say, to the party still paying the full value of execution, including the principal amount and any penalty and interest.
Well,
so they can't sell for less than was actually due.
I understand, but what I'm trying to figure out is this: if the county, if they weren't sold till after the calendar year, who gets the penalty? Does the county coffers get the penalty, or does it go back to, for instance, Sandy Springs?
It would not go to the local government if it's sold before that penalty is incurred.
Oh, I know that. I'm talking about
after.
I'm talking about after the penalty is incurred. Who gets the penalty?
Oh, it goes to the third-party holder.
No, I'm obviously not being clear. Let me try to clarify, because here's my question: the penalty.
Yes, sir.
Let's just assume that the tax commissioner holds on to the lien, and the penalty comes up, and it's eventually paid.
Okay.
Does the county get the 10%, or does the local government get the 10%? Let's just say
Neither
that they're
one.
trying to collect.
Neither one.
No. I'm talking about if the county, if the
they
tax
hold it.
commissioner holds on to it.
Beg your pardon. They never sold it. It stays and goes to the county coffers.
Okay. Because here's my concern there. The way we have it going right now, for instance, in Fulton County, is that Sandy Springs or Fulton County School Board, Atlanta Public Schools, gets 100% of their tax revenue, the way we have it now. My concern is, does this bill make those tax liens less marketable, so that our local governments are not going to be so that we're going to have a harder time selling them, so our local governments are going to have a harder time keeping that stream? That's my question.
I agree. It's a good question. And I have had conversation with others who do tax execution, realize these bring not only the 10% penalty, but also a 1% interest per month. So they earn 12%. That is on one of the probably the primest assets you have as a tax execution,
yes, sir,
which is the eventual ownership of that property.
Yeah.
If you go through the full redemption time and foreclose on it, they say there still be a good market that they have not been able to get into buying them because of the way the tax commissioner does the sale of these liens. He only sells to very selected people, but there are others who are willing to buy them, recognizing they get a 12% return on the money.
Yeah, that's my biggest concern. Is I want to make sure that we don't do anything here that makes the liens, for want of a better term, not marketable.
Yeah.
So that my second question, and it's something that you and I have always agreed on, which is how egregious it is that a hypothetical tax commissioner would receive 50 cents per tax lien. Where exactly are we abolishing that?
That is where you have the section removed under Section 4, where it says this title is further amended by repealing Section 48-441 relating to redemption by a creditor without a lien and designated as reserved.
Third thing, someone handed me an amendment that was hopefully going to take care of the grandfather clause that a hypothetical.
No, I'm sorry. Let me back up. I misspoke. Yes. Section 7.
Okay.
Mr. Lindsay says said title is further amended by repealing Section 48-163 relating to a fee for the issuance of tax executions and the allowance of costs of execution and designated as reserved.
Your aide over here was already correcting you. So
thank you.
She was doing her
job. She does me, thank goodness, all the time.
The third question I've got is that someone handed me a proposed amendment that would hopefully deal with we've been trying to get rid of these egregious contracts that we have between tax commissioners and local governments, in which they're able to use government assets to do tax collection for a local government, and yet the tax commissioner gets an individual payment. Have you had a chance to examine this?
Is that the one it does based upon the state policy?
Yeah, it has to assignment.
I did that myself.
Okay.
I'm happy to have his amendment.
Okay,
friendly amendment.
Okay.
All right. We have other people signed up. Mr. Chairman, do you have anybody else you want to bring up at this time?
No, sir.
On the list?
That's all. Thank you.
All right. Next person on the list for House Bill 819 is John Walraven. Thank you, Mr. Waters.
Thank you very much.
Appreciate you coming down today. Mr. Walraven, thank you for coming today, and please, if you would, introduce yourself and tell us who you're with, and we'll be happy to hear from you.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I'm John Walraven. I represent Ray Investment Group, which is a wholly owned subsidiary of Investa Services. And I am here today. I don't have a copy of your substitute, but I was reading the original underlying bill.
Here you go. You want to reach up here and
Sure, thanks.
make sure you have one in front of you. Substitute 819-4109S. Right there.
The Groundhog Day was very appropriate. We have been up here doing this for a few years. I came here specifically to talk about Section 2, which has been amended from the as introduced version. I've been working with the sponsor of the bill, Representative Chairman Martin, with it off and on, but he was unable to be here today. So I am here. I brought a folder to each member of the committee today and put some information in it, and I would appreciate it if you take a quick look at it if you can. My client is engaged in essentially what is the privatization of delinquent property tax collections. Rather than having a large staff at the tax commissioner office, as some counties do, to collect delinquent taxes and perform foreclosures, the privatization angle will go to the county and pay 100 cents on the dollar for the amount of taxes owed, and they will take possession of the lien and begin billing the delinquent taxpayer as if they stand in the shoes of the county. Really, Fulton County is the primary user of this law, and Gwinnett County has to some extent. But one county that does not use this form of tax collection is DeKalb County. And DeKalb County, and I've got these numbers from 2013, DeKalb County issued 1/3 of the amount of liens that Fulton County did. So Fulton County's got 3 times as many liens issued. However, DeKalb County foreclosed on 3 times as many homes as Fulton County did. And there's a big reason for that. You can foreclose on a home in 90 days in Georgia if you're the tax commissioner, but if you privatize the collection of these taxes, state law requires 1 full year for that private company to hold on to that lien. That private company could enter into a payment plan with the taxpayer, as opposed to the tax commissioner, who does not have that authority under the law. Foreclosures are expensive. They displace folks from their home, and the fees and the costs and the redemption premiums are items that my client really doesn't have to visit with very often. And they not only get to stay in their house for an extra year by law, but the business model is really for them to stay in it for 2 or 3 more years. In all candor, my client would much rather let the taxpayer pay the bill when they can in full than take ownership of their house for a tax bill that might be, just a couple of $1,000s. And that's the bottom line. It keeps people in their homes longer. And after 90 days, Georgia has this 10% penalty. What are we talking about here with this 10% penalty? Representative Lindsay had a question a few minutes ago that was pretty well on point. if you look at page 2 of this little thing I put together for you, there's a pie chart, and it shows the 15 or so governmental entities that the tax commissioner of Fulton County collects for. Collects for the Fulton County Board of Education, Atlanta Public Schools, City of Sandy Springs, Roswell, Milton, Johns Creek. And only 22% of all taxes collected by the Fulton County Tax Commissioner are for Fulton County. So most, 80% of what the Fulton County Tax Commissioner does is take the taxes in and then give them to the school boards and to the cities. The only people that will be hurt by delaying the money going to the school boards and the cities will be the kids in school and the folks that live in that city. Because as the chairman said a few minutes ago, that 10% penalty does not go, it does not pass through. It stays with the county. So you'll see in my little pie chart right here, you've got 22% of the taxes being collected for Fulton County, but 100% of the penalty goes to the Fulton County General Fund. So I've been down here just 15 years or so, but it's been a long time since I've seen people from cities in Fulton County want to send more money to the Fulton County General Fund. And if we wait and we allow Fulton County to keep 10% penalties on delinquent tax loans for not trying to collect the taxes, we're really just doing the Fulton County Unjust Enrichment Act of 2014. We're going to hand them 10% penalty for all of these delinquent taxes for not trying to collect the taxes. So I want you to think really hard about this penalty. I want you to think really hard about this policy. Are we really going to tell a Sandy Springs taxpayer that we know you didn't pay your taxes on time, and we know that your city's not going to get 100% of their revenue, but as soon as we get paid, we'll give you your 100 cents on the dollar, and we'll keep the penalty for not even trying to collect it. It's not good policy. If we want to stop tax lien transfers in Georgia, we can do it a lot cleaner, easier way. But putting tax liens on the shelf for a year to collect 1% interest a month, also that at the end of it, no one's going to be wanting to buy these things. You're going to have to go ahead and pay somebody else's penalty and pay a year's worth of interest. And, this is just the nature of the business. Declining property values have taken a hit on these. The newspaper really likes to say that, there's a 10% penalty on everybody who doesn't pay their taxes, but it's not true. Only almost 40% of the unpaid tax bills in 2013 for Fulton County were for under $500, and by state law that means no 10% penalty applies. So we're talking about really 60% of the tax base is exposed to the 10% penalty, not 100%. So when you read stories about selling the liens before 90 days and then it was worth $20 million worth of liens, so automatically they got a 10% penalty and they made $2 million, it really just doesn't work like that. The math's a little more complicated. But I'll wrap up by just saying that the reason that these transfers occur before January 1st is so school boards and cities can get their revenue. This is not a loss to the county of revenue. The 10% is a penalty to deter the failure to pay taxes and for the cost of collecting the delinquent taxes. The 10% is not a revenue stream for the Fulton County General Fund, and we would like to see that preserved as a policy here in Georgia. It was never meant to be a source of revenue. It was meant to encourage on-time tax payments. And with that, Mr. Chairman, I say thank you very much, and I'm open to questions.
Thank you, Mr. Walraven. Does any members of the committee have a question for Mr. Walraven?
I do.
Go ahead, Mr. Chairman.
Mr. Walraven, if it's not a monetary stream, then there should not be any problem with going ahead and allowing the county to hold up the sale of these liens until that 10% penalty has occurred if your clients are not desiring to have it or needing to have it because they're going to be earning 12% interest as a 1% per month on those tax liens that they buy when they do buy them. That happens, correct?
There's a 1%, yes, sir,
Yes,
1% interest per
Now,
month.
if they buy them before December 31st, which has been the practice, and that penalty becomes placed on the tax lien after they have acquired the tax liens, they pick up immediately a 10% gross profit on that tax lien by holding it just a few days. Is that also true?
On what we're determining is probably about 30 to 35% of the liens that they buy. We don't get to cherry pick.
How about dollar volume?
I don't know.
You say 40% is under 500.
40% is under $500.
What does that amount to as far as dollar volume, though? I'm not looking at percentages numbers. I'm looking at dollar volume.
I don't know. I don't have
You don't have an answer. Okay. So if it's just a matter of money flow, is there any reason why the county should not be the one to also receive the benefit of that penalty, since they're the ones that had to do the tax billing? The failures have been paid of taxes by the property owner to the county, not to the third-party buyer of Vesta Holdings, is it?
Well, the third-party buyer pays 100 cents on the dollar to stand in the shoes of the county.
I understand.
So the county, who has done absolutely nothing to collect the taxes except
Is
send
that
out
your
a
word
bill.
on that? They've done nothing?
They sent out one letter,
They've done a bill,
right?
and the taxes is owed to the county,
Or
correct?
to the cities,
so
or to
the
the school
failure to pay
boards,
the
or to
county is
CIDs.
something that should receive a benefit for that failure as opposed to Vesta Holdings.
It depends on whether or not they've acquired the lien, sir. I just don't believe that the 10% was meant to deter late taxes and to pay for the cost of collection. And for the county to hold the 10% while another party is paying the cost of collections runs contrary to the public policy of the state of Georgia.
Okay. That's your opinion?
Yes, sir.
All right.
Any further questions?
Sure.
Okay. Thank you, Ms. Walburn. We appreciate you coming today. I have two other speakers signed up. The first is Richard Royal. Mr. Royal, you bringing Dan Ray with you?
Yes, sir.
All right. I had him on here too. All right. Appreciate y'all coming today. Please tell us your name and who you're with, and happy to hear from you.
Oops. There we go.
I'm Richard Royal. I represent the Georgia Association of Taxing Officials. That's GATO. We're here to express concerns on the practical administration of the due diligence only. We're not here to voice any opinion on policy on tax liens, so we have some concerns. Mr. Dan Ray is with me. He's a former commissioner of 20 years, and he's the executive director of GATO, and he would like to express some concerns on the administration as a tax commissioner. Thank you very much.
Thank you, Mr. Ray, for being here today.
Well, thank you for the opportunity to come and speak. I'll kind of run through it section by section, but the under Section 1, paragraph A1, the due diligence, we understand the due diligence will occur basically after we've sent out the initial 30-day notice is how we refer to it, and then what gets returned in the mail, we're to go back and then attempt to search. That could be problematic for some of the counties, so they just don't have the staff to do those things. It's not a situation where it can be automated, because you have to take what gets returned and then go in and do that individually, piece of mail by piece of mail by piece of mail. It's heavily labor intensive, and there is a cost to those internet searches. So we would suggest that could be very detrimental to some of the smaller counties, especially. I was tax commissioner, as Mr. Royal said, for 20 years in Rockdale County. And even in my small county, out of 36,000 tax bills, by the time I sent out somewhere between 2,000 and 3,000 delinquent notices, I would still receive around 750 back in the mail. And to sit and to have to process those manually one by one is pretty problematic. Now, I did it in my county, but certainly it was over a 2 or 3 month period that we would try to search through those things and resend out the notices. But in the meantime, we did not execute it, but actually record and issue the FIFA because we sent it out to the owners. So I suggested that could be very problematic to some of those who don't have the staff. I was fortunate that I had the staff that could do it, had access to a internet search engine that could do those kind of things.
I'm sorry, Mr. Ray, where were you the tax commissioner again?
Rockdale County.
Rockdale County, thank you.
Yes, sir.
Mm-hmm.
And also kind of philosophically, this is my opinion. I mean, it is ultimately responsibility of the owner of the property. Here in Georgia, we operate under that we're responsible. We're supposed to take care of our own business. We're supposed to take care of our own property. Part of that responsibility is paying those taxes. And certainly part of that is I'm supposed to provide to the taxing authorities in the county and to the state where I live. And failure to do that is my problem, my fault. It should not be on the burden of the county or the state to have to track people down for them to pay their taxes. Now, we do that when it comes time for a tax sale. We do a due diligence search and search these people out so that they are aware that we are levying on their property. Under Section 1 on paragraph 2, I would ask the chairman to consider the changing of one word in there, and it's on line 28, and I'm reading off of the substitute bill 4109. And there it reads that the
09S.
Yes, I'm sorry, yes,
Mm-hmm.
4109S. On line 28, it says property during and after the year January 1st, but on or after the due date of the tax bill year whose deed has been duly recorded. I was a party to this originally, this language, when it was written. The intent of the representative at that time was for us to be able to notify people who bought property after January 1st, but before the taxes became due. And then it was changed, so it should read on or before the due date, so that we're notifying those people who bought during the year. Anybody that buys after the due date, if their lawyer doesn't tell them their taxes outstanding on that property, they need to be firing them a lawyer, because of a due diligent title search should show that their taxes due. So if somebody's bought a piece of property that have taxes due, shame on them for not being aware of that at their closing. But it's somebody who's bought earlier in the year who may not be aware of that. So I would ask that you consider that, sir. On Section 2, on the transferring of the FIFAs, I would ask that you consider two exceptions to the time limits. One would be, and these are things that I dealt with in Rockdale County, if you have an owner financing a piece of property, many times they do not have the sophisticated contract that allows somebody to, if they don't pay their taxes and the owner who owns that security deed comes in and pays the taxes, they didn't necessarily have that built into their contract that they could have an automatic trigger to do a foreclosure. And so a lot of times the owners of the security deed on an owner financing wanted to buy my FIFA. That way they had some claim over the property that they could see to it that they got their money back. The other incident is where you have a family situation. As the gentleman pointed out, let's say mom or dad is widow and they're trying to pay the property and living on Social Security, and they just don't have the money to pay the taxes. So you have the good son. I'm going to pick on the guys today since I'm a guy. You've got the good son, you got the bad son. Good son comes in and pays mom's taxes. Well, of course, the bad son is not going to help the good son out and pay those taxes. But when mom finally passes away, he's going to be at the probate wanting his half of the land. And the good son should be able to recover his investment of where he protected mom's property all those years and be able to get that back out of the estate. And by presenting that FIFA to the judge, he can show that he paid it and was being the good son. And those things shouldn't be subject to a time limitation. I understand what you're trying to do with the other circumstance, but those were two items there that I had to deal with in Rockdale County. Section 3 you've talked about. Section 4 you've repealed. Talked about that. Under Section 5, we get into the grave details of a tax sale. Please understand, we've been talking about two different things here. We've been talking about selling a FIFAs, and now we've switched gears, and we're talking about redemption of property from a tax sale. That's different from a selling of a FIFA. We have committed to a tax sale at this point, and the person who has bought the property at the tax sale is, under current law, has a right of a premium of 20% of what they paid for it at the tax sale as part of their taking on that responsibility. And I agree, I don't think it was ever envisioned that we would have people bidding up properties to the excessive amounts that we have seen in the past 5 or 6 years. My county was one of the first counties to see the super lien, and I don't want to get into that because that's not our business. But at the same time, we don't want to take the reward for that risk that somebody takes who's actually out here doing it for the right reasons completely out of it so that we can't sell a piece of property. So what I would suggest you take a look at is that the 20%, and I understand be 20% on the writ of FIFA. What we would suggest is that it be 20% on the amount of the tax bill that was paid at the day of the tax sale. Because the FIFA, when it's issued, could be, like he said, 2 years ago. In the meantime, there's been a lot of interest and penalty. There are collection costs, advertisement, service fee, and those things have been added to the tax bill. So we would suggest that it be 20% of what was paid on the tax bill, less the excess funds. The excess funds, of course, would gain at the 1% per month. But the 20% would be on the tax bill and not the writ of FIFA. Another suggestion would be that the 20% be strike out the 10% language. It'd be 20% a year, since you've now brought it down, say where we had a $100,000 excess bid, but there was only maybe $2,000 in taxes. Well, now the 20% is not on the whole $100,000; it's now 20% on the $2,000. So you got a much smaller amount there. So I would suggest we take a look at doing 20% per year and strike the 10. And the other issue would be, since we're now giving that kicker on the smaller amount, that the language dealing with the sheriff's fees and the advertisement, allow that cost to be charged immediately. Right now it reads 30 days if it's not redeemed within 30 days, because the cost of advertisement and the cost of sheriff's service could actually exceed the 20% that the guy would be receiving on the redemption. If somebody did come in the 11th hour, let's say, to redeem the property, and he's added, he's had that cost incurred of advertising the property, having the sheriff do all the sale notices, he could actually lose money, and we don't want that happening.
Mr. Ray, did you talk to the author of the bill who's behind you about these things?
No, sir. We did not get up here with all the ice and snow last week. We were trying to get up and meet with him.
All right. I'm going to suggest, Mr. Chairman, that appropriate time that perhaps a motion to table this until they have a chance to talk about it.
Okay.
A lot of things.
That's great.
Coming up the first time.
Mr. Ray, any other points you have before?
Well, I'll talk with the author about it. We would like to add a section 7, make 7 number 8. And while we're in this about the ripening of ripening of deed by prescription, since we're lowering the return, we need to make it to where the deeds will ripen with the passage of time of 4 years. The Georgia Supreme Court ruled last year that without the definition of what the ripening by prescription is, their prescription was it had to be 7 years of adverse possession. Well, the instructions we give people at a tax sale is that you don't own the property, so therefore you can't go upon the property. Otherwise, you could be charged with trespass. So how can somebody have adverse possession if they're in danger of trespass? So I'll talk with the author, see about adding that in there, that we define that ripening prescription as a passage of time.
Mr. Bart, we appreciate you, Mr. Ray, rather, we appreciate you coming today. It sounds like several very good suggestions that need to be discussed with the author, and Chairman Willard has presented the bill today, and he agrees with that. So unless there are any further questions from the committee for Mr. Ray or the presenter of the bill, Chairman Willard, or unless the chairman has any further comments, the chair's intention at this time would be to hold the bill for a later committee date so that you can get together with the author and work on those things. Okay?
Thank you.
All righty. I believe that concludes this presentation of that
Thank
bill,
you.
so I'll give it back to you, Mr. Chairman.
Thank you, Mr. Fleming. We have no further bills to come before the committee and no further business. The chair will entertain a motion to adjourn. We'll stand adjourned. Thank you.